Thank you and welcome to the fourth hearing for Portfolio Committee number 8, Customer Service, for the additional round of hearings for Budget Estimates 2025-2026. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Emma Hurst and I am Chair of the committee. I welcome Minister Hoenig and accompanying officials to this hearing. Today the committee will examine the proposed expenditure for the local government portfolio. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome and thank you for making the time to give evidence today. Minister, I remind you that you do not need to be sworn as you have already sworn an oath to your office as a Member of Parliament. For all other witnesses, I remind you that you have also already been sworn before this committee during this inquiry and therefore do not need to be sworn again today. Today's hearing will be conducted from 9:15am to 5:30pm. We are joined by the Minister for the morning session from 9:15 to 1pm with a 15-minute break at 11am. In the afternoon, we will hear from departmental witnesses from 2pm to 5:30pm with a 15-minute break at 3:30pm. During these sessions, there will be questions from the opposition and crossbench members only, and then 15 minutes allocated for government questions at 10:45, 12:45 and 5:15pm. We will begin with questions from the opposition.
Thank you, Chair. Good morning, Minister. How are you this morning? I might start with the Premier was quoted in the Sydney Morning Herald in late October, and I'll just read it. It's in relation to councils. And he says, "The secret here, though, is that local government is just an act of the state parliament. We effectively have eminent domain over their decisions, and they can be a pain. Yeah, they can. But we've been rolling over the top of them for the last 2 years." Minister, do you agree with the Premier? Is local government a pain?
It certainly can be. It's a democratically elected third tier of government, and having spent 30 years in local government, I can tell you I was a substantial pain to both the federal government and state government, as most people will testify to.
Mm-hmm. Then,
I would say this though, and that is that you need to take the Premier's comments into context, and that is that he was referring to planning issues.
Housing, yes, I know.
And he was referring to the desperate need the state has to provide, more housing, and there have been a lot of parochial approaches by local government that have obstructed that, and I think if you take what he says in context, he is right.
Okay, thank you, Minister. So now you're in the other seat, you're not in local government, you're a minister. Is it a government that respects local government?
Oh, I think if you ask the sector that they will tell you that we certainly are, and most significantly, our democracy provides checks and balances for 3 democratically elected tiers of government, and there is a requirement for all of us, despite the tensions and the frustrations that we create for each other. I mean, the tensions we have with the federal government on a state government basis are also there, not always apparent.
Yeah.
But
I remind you.
In fact, I just want to add to that, if I can, Mr. McDonald, is that my main mission since I've been Minister for Local Government is to enhance the reputation of local government and the local government sector in the eyes of the community, and it's been my mission since I've become the Minister for Local Government.
I'll ask you about that record later. Are councils partners or roadblocks? And you did
No,
say...
councils are independent, democratically elected tiers of government required to discharge their responsibility in accordance with a variety of laws of New South Wales.
So you haven't answered that question, but I'll move on. So Randwick Council, it's close to...
It's one of the councils in my electorate,
in
actually.
your electorate. So Minister, do you remember a media release you put out on the 1st of September, excuse me, announcing stronger penalties and laws for local councils? I got that one.
In relation to what in particular?
Just faster hearings and lots of things, actually. But as the Minister and to do with codes of conduct and all manner of things, as the Minister responsible for the Councillors' Code of Conduct, are you aware of an article in the Daily Telegraph from the last month, 12th of February, that reported more than 140 residents have complained about Councillor Philippa Veitch on Randwick City Council?
I am aware that there have been a lot of complaints in respect of something I think that Councillor Veitch might have either shared or said at a council meeting in relation to a particular issue. Yes.
Yeah, I could. So on the 14th of December, the same night of the Bondi attack, she's sharing on Instagram a post describing the attack as an act of men's violence. Similar, she liked a post which had been shared by pro-Palestinian activist group Teachers for Palestine, New South Wales, which read, "No to genocide in Gaza, globalise the Intifada." And she appeared to like the post on December 21, just one day after this government announced proposed changes. And then on the 9th of January, posting solidarity with Randa Abdel Fattah. And I could go on. As the Minister responsible for the Councillors' Code of Conduct, are you aware that the Randwick City Council has called in an external investigator to probe these posts made by Councillor Veitch?
If you're asking me as to my role as Minister in relation to Code of Conduct breaches, I can say to you that I don't have a role.
No, I'm not, I was asking whether you were
aware as to whether or not there was a Code of Conduct complaint. I think they might be. They don't come to me or the OLG. They
so
operate.
you are aware?
I think I recall seeing something, may well be as a result of some media coverage, but I have no role to play.
So in that awareness, were you also aware that risk management consultancy firm Centium would be reviewing Councillor Veitch's behaviour?
I'm sorry, could you just, I just didn't hear that.
Sorry, that risk management consultancy firm Centium would also, well, she's going to be, sorry, that group is reviewing Councillor Veitch's behaviour?
No.
No? Okay. And do you think that is this appropriate conduct that your government would expect of an elected councillor?
Firstly, I'm not really the sort of person you should direct those sorts of questions and ask for my views in relation to it, because you could probably anticipate what they might be. And I'm not the one that's seen to bring dispassionate, would not be seen to bring dispassionate and objective opinions to those matters, bearing in mind my background. And I don't think me expressing opinions when I have no role to play about what somebody may or may not have said that may not have been unlawful actually aids community harmony or cohesion. So I really shouldn't be expressing a view, particularly if the matter is pending, and I would hardly be seen to be impartial in expressing views about those sorts of statements.
Okay, then you'd be aware then that on this same council, the Randwick Council, that Labor councillors made a deal with the Randwick Greens that would see them taking mayoralty this year?
Am I aware that Labor entered into an arrangement with the Greens on the council? I'm not specifically aware of any deal they might have entered into recently, but they have in the past. I'm aware of. But that's not unusual because they're hardly likely to enter. The Greens are hardly likely to enter into an arrangement with the Liberal Party.
Thank you. And as the minister responsible for, say, the councillor's code of conduct, do you believe that Councillor Vetch would be permitted to run for the role of mayor whilst under formal investigation for her conduct?
Point of order.
Yeah, there's been a point of order taken.
Just concerned in terms of the prohibition effectively on adverse comment on third parties, and obviously this has gone a fair way in terms of the questioning, but it's in a context where the councillor, if indeed there is a code of conduct process, is prohibited by state law from making any comment about it, and indeed it's probably arguably a breach of state law that it seemed to have been leaked in the first place. We're now leading to a suggestion that she's somehow not a proper person to fulfil a particular public office. It's a flagrant breach, I would suggest, of the prohibition on adverse comment on third parties.
Thank you. Look, I'm going to get some advice from the Secretariat on this one, and I do think the Minister's been handling the line of questioning very well, so I appreciate that, Minister. But I'm going to get some advice. If you are happy to move on to a different topic,
Sure.
and we can come back to this. Thank you.
Okay, I'll move on to a different topic then. I might turn to Bayside, if that's okay. Do you stand by your previous evidence to this committee that pre-selection timing was not raised with Mr Whitworth?
I'm going to say this generally in relation to that subject matter by saying this. There is a matter before the court at the moment relating to somebody who's charged with quite serious criminal offences, and I'm mindful of that and saying anything that might prejudice that that matter.
On a point of order, Chair. Point of order.
Sorry.
The Minister's trying to avoid an answer by raising a court case that has absolutely nothing to do with the question that's been asked. And that shouldn't be allowed to be part of budget estimates. The Minister should answer a straightforward question as to whether he raised Bayside pre-selection as a consideration of Mr Whitworth, and it has absolutely nothing to do with the veracity of the answers that Bill Saravanosky may or may not have given at ICAC in private examination.
Look, sorry, I actually missed the exchange because I was getting advice from the Secretary on the last point of order, but I will remind the Minister to make sure that he's answering the relevant questions. I'll leave it with the member who was asking the question if she wants to re-put the question and ensure that the answer she's getting is clear.
All right.
Thank you.
Well, I might move on to my next question then.
Well, but can he answer this one?
It's up to the
my
member
next
if she wants to
question
put the question.
might lead it to an answer, I'm not sure, but then I can go back to that question. So Mr Whitworth's written statement directly contradicts your testimony, so how do you explain the discrepancy?
I haven't seen his written statement, firstly. Secondly, I refer you to answers I've given in the Legislative Assembly, and other than the answers I've given in the Legislative Assembly, which I adhere to, I don't propose to answer any questions in relation to that matter for the reasons I was just articulating, plus other reasons if you would like me to give them to you.
So does that mean you don't want to talk about Bayside?
I don't think I can in all the circumstances, and I'm happy to give you detailed reasons if you would like me to give them to you, and invite you to attention to certain documents of which you no doubt are aware.
So with regard to documents, have you reviewed any of your diary entries, file notes, emails or messages to confirm your recollection?
my recollection in relation to one particular matter was refreshed, and that involved a letter I think I wrote to a committee of the Legislative Council relatively recently,
Okay.
which basically confirmed the accuracy of my recollection I'd previously given.
And will you table any other records of your communications with Mr Whitworth regarding the NCAT submission?
I can't, for reasons I can explain to you if you like. Would you like me to do that?
Yeah, I would.
Yeah.
I'll do that in reference to a letter sent by the acting solicitor to the Independent Commission Against Corruption, written to the clerk of the Parliament of New South Wales Legislative Council, dated 21st of May 2025. And in part, and it relates to obviously some correspondence in relation to a Standing Order 52 resolution. It says in part, in December 2022, the Commission referred documents and other information to the OLG under Section 53 of the Independent Commission Against Corruption Act 1998, the ICAC Act, for the purpose of conducting its own investigation to determine whether disciplinary action should be taken against Mr., and I won't repeat his name.
Well, it's Bill Saravinovsky. I mean, what sort of games do you
Order.
Well, I'd rather not, because he's
This is so
facing
weird.
criminal
This
proceedings,
is so
Mr Latham.
weird.
Please,
Or-
you've got a bit of
order.
fairness.
Unrelated to anything you're
Order,
talking
Mr
about.
Latham, you'll have your chance to
Oh,
ask
it's just
questions. later.
bizarro land with this guy.
Order.
The material was disclosed to the OLG and later to the Minister for Local Government with restrictions on its use pursuant to secrecy provisions of Section 111 and 112 of the ICAC Act. This allowed disciplinary action to be taken against Mr. Whatever his name is, whilst preserving use of the material for the purpose of ongoing work by the Commission on this and related matters. Accordingly, the Commission's position is that none of the material is disclosed to the OLG or to the relevant minister, or any material created by the OLG or the relevant minister to the extent that it refers to or annexes Commission material should be produced to Parliament. Now, that's the letter that was sent to the Legislative Council clerk, and the Chief Commissioner gave evidence on the 20th of August 2025 and said, look, I need to be very careful. Apart from the criminal matters that are forward, there are other issues of some sensitivity that I don't want to go into. There may be an appropriate time when the situation may change, but I need to be very careful. I do understand your interest in this matter, but I think you need to take a pause on this and just let the process take its course. So I would ask you to do what the Chief Commissioner has asked you to do,
Point
and
of
that
order,
is
Chair.
just
Point of order.
pause
Point of
and
order.
wait till they're finished their
Yes.
work.
Point of order.
Sorry, Minister, there's been a point of order.
Yeah, this minister is deliberately playing games with this committee to the point of absurdity. He has read out material from the ICAC which related to surveillance activities about Bill Saravinovsky and his relationship with the developer. They bear absolutely no relation to the matter that's before the court with the DPP, which is the veracity of Saravinovsky's private examination and whether he purged himself. This minister has a habit of playing legal games and tricks, thinking this committee is just full of idiots, and believe his lame excuses
Order.
for why he won't face up to his
Order.
own lies,
Order.
his own misuse of ministerial office,
Order,
and
Minister. I
legitimate
understand your point of
interrogation by
order.
this committee members.
I understand your point of order. My understanding was that the Minister did, first of all, the Minister can answer in any way he sees fit. And my understanding is he did ask the member if she wanted that to be read out. I will leave it in the member's hands whether she feels that that is an adequate answer and to be able to interrogate that further.
I can see that it's related, but what the questions I'm asking you are separate to the issue that you're discussing. So I'll ask, did you have any conversations, direct or indirect, where the political timing of the matter was discussed?
I refer to the answers I gave to the Legislative Assembly. They're contained in Hansard, and that's as much as I can say at this stage.
So when did you give these answers to the Legislative Assembly? Was that like a question time or?
Question time, yeah.
Question time, sorry. Okay. So Mr Whitworth says you raised the NCAT matter involving he who should be not named, Bill Saravanowski, with him on multiple occasions. Are you saying the Deputy Secretary evidence to Parliament is incorrect?
Well, I haven't seen what Mr Whitworth...
That's not the question. The question was, are you saying that his evidence is incorrect?
Well, I don't know what his evidence is.
Well, why have you not?
Objection. Can I just flag, I don't believe that I've made that statement to this committee.
Oh, okay.
And I am quite concerned that you're now referencing, perhaps if I could get the Chair's attention for a second. Sorry, Chair.
Sorry.
I'm concerned that I'd like to object on the basis that this appears to be going into evidence that may have been given in other committees, that was given in camera, and seems to be utilising that information.
Thank you.
Well, to the point of order,
To the
Chair,
point of order, yeah.
Mr Whitworth furnished a citizen's right of reply to the Legislative Council. It's been tabled by our Privileges Committee, and in it he says that the Minister raised with him Labor pre-selection schedule as a consideration for the handling of the Saravanowski matter. That's clearly on the public record and a legitimate item of interrogation by this committee.
Sorry, can I?
Yes.
If that's okay to respond, but my citizen's right of reply did not talk about the number of times.
No.
And I was asked, sorry,
All right. Well,
that question, that evidence that you are quoting is from, no, I can't even say because I am uncertain as to whether I would be where I stand in terms of the standing orders and a potential breach of Parliamentary Evidence Act.
I'm going to have to get some further
Chair,
advice
I
on
would
this
like to
as
seek
well.
some advice from my General Counsel as well.
Yep, certainly.
To protect
Yep.
my Deputy Secretary.
And I'll be seeking some further advice on that one as well before.
so my time's up.
Yes, your time is up. I'm going to throw to Dr. Conn first. Thank you.
Good morning, Minister.
Morning.
As I'm sure you're aware, the Legislative Council is considering a disallowance of the new Model Code of Meeting Practice.
Yes.
And that's in response to strong concerns we've heard from the local government sector. I acknowledge that disallowing the whole lot would be using a jackhammer to crack a nut. What feedback have you heard in terms of the implementation of the new Code of Meeting Practice, and are you open to amending it?
There has been some feedback. There's a lot of the sector that didn't like the idea of private briefings having been being outlawed by the process, but I've been very firm on that now from the very beginning. That's inconsistent with transparency and Chapter 4, Part 1 of the Local Government Act. And so I've made it very clear to them that this concept of going behind closed doors for a variety of very good, not only public policy reasons, but also legal reasons is not appropriate. I've got some feedback that there are inadvertent consequences as a result of some changes. For example, the utilisation of remote attendance at meetings, which impacts upon some particularly remote or rural councils or people in specific professions. And there's been some concern expressed, community concern expressed that about the public forum nature of being relatively restricted. When you draft these codes, it's like any piece of legislation or regulation. You can have unintended consequences, and I'm happy to revisit those areas where I've had drawn to my attention. You have drawn to my attention areas of unintended consequence, and I'm prepared to revisit those. Also, in particular, you drew to my attention that a number of councils are trying to find devices to avoid the provisions of briefing sessions. After I spoke to you, the matters in relation to Parramatta were drawn to my attention, and I read the report that was written to councillors for Parramatta Council, and I'm extremely critical of that. That is just a complete defiance of the draft code of meeting practice. It's not just a subtle avoidance. It's completely inconsistent with it. I've asked some advice from the Office of Local Government as to whether or not I should give a draft performance improvement order to that council. But I do make it very clear, if I expect them to conduct their affairs in an open, transparent way and give effect to Chapter 4, Part 1 of the Local Government Act, and if there is any inconsistency in those provisions of the code, I'll change that very quickly. Or alternatively, I'll legislate. I'll seek to legislate, but I just can't have it. You tell me there's others, and I'll have a look at those others. But if I need to change that to make it stronger, I will. People cannot have confidence in their ability of their councils if they're cobbling together, making routine and budgetary decisions behind closed doors.
Thanks, Minister. I think many people will be very pleased to hear that you're prepared to revisit some parts of the new Model Code of Meeting Practice.
Yes.
You brought up first the issue of private briefings, and there are certainly many councils across the state who have taken your advice in this regard and formed committees to go into Committee of the Whole to have less structured discussion on the public record as it should be. There are certainly some councils I'm aware of, for example, that are still having private briefings simply the day before the agenda is published, which is certainly in keeping with the letter of your new Code of Meeting Practice, but not the spirit of it. And the concern from many people, including myself, is in terms of the confidence of the sector. You're now telling the public that there aren't any closed-door briefings happening anymore, but what's happened is at several councils that practice has continued, and I understand that many councillors value the opportunity to have briefing sessions before meetings, that discussion without having the urgency of a decision or a proposal before them has merit, and I would agree with them, but I think certainly there's a need for additional support to do that in a way which is in keeping of in spirit of what you're trying to do. So I suppose is it your intention to provide additional support to the sector to do that in a way that's in keeping with the spirit of the regulation?
I'm going to make it very clear to those councils that are not adhering to what is intended, what I expect of them. If it requires a change, I'll change it quickly. If it requires legislation, then I'll seek to legislate. Chapter 4, Part 1 of the Local Government Act, which has headed up open meetings, has set up a regime requiring openness and transparency of council decision-making processes and provided exemptions as to when the press and public can be excluded. And the Parliament since 1993 has been legislating to restrict the ability to exclude the press and the public from decision-making processes. And not only is it a corruption prevention mechanism, it's important for public confidence in the decision-making process. And significantly, really significantly, as I have explained to councillors when I go and visit them, is that unless they sit as a council or as a committee, they have no statutory authority. They have no ability, for example, to exclude the press and the public from confidential material. Just because a council officer gives a councillor a document not in a council committee and says this is confidential, doesn't mean that it is. It only becomes that when it's given statutory force, when the council sits as a committee or a council meeting and determines that the matter remains confidential. So there's a variety of decisions. It's a cultural change. That's why these changes always take so long, Dr. Con, is that you can regulate and you can legislate and you can compel, but effectively to make meaningful change, you've got to take them with you on a journey. It's pretty hard sometimes to change their way of doing things.
Can we come back to the question of audiovisual attendance at meetings? Because this has had, I think you used the word unintended consequences. I would definitely agree with that.
Yes.
While I appreciate that theoretically there are circumstances where audiovisual attendance could be overused, for example, by people who don't even live in the state, there have certainly been really compelling and distressing examples brought to my attention of people with significant caring responsibilities or working people who've been unable to fulfil their duties as an elected councillor as a result of the new rules. And there's even been 2 councillors who've resigned from their roles as a result of that change, which I hope wasn't your intention in bringing that forward. Do you agree that there's a middle ground somewhere with slightly less stringent regulation of the audiovisual provisions than what you've put in place?
Yes, Dr. Connors, I just said to you a moment ago, I couldn't envisage every conceivable circumstance. And often what happens with not just me, but with the regulator is that you see all the problems, you don't necessarily see all the good work, and that you start making decisions or regulations based upon sort of specific problems. So there were certainly problems with the current arrangements. It was being abused in a number of quarters, and so I sought to address it. And I did have the principle that, look, you stand for election, you've got to attend at least 10 meetings. A council's got to have at least 10 meetings in a year. You can make your arrangements to attend a meeting. You can't go and hide behind audio visual just because it's a difficult decision or there's a whole pile of people turning up to wanting to be heard at a council meeting. Or you have a situation at one council in a mayoral election when someone's in hospital, to make sure they got the numbers, they unlawfully didn't allow the councillor to attend by audio visual. So I'm trying to address those circumstances, but I had, from Burke, Mayor Burke asked me, if the road's washed out and the councillor can't get there. And I said, well, I didn't intend that. You made some reference to a council, an Albury council, that has got special circumstances with his work. So I'm going to have to revisit it. And when I do, I'll send it to Country Mayors Association. I'll ask the rural councils for input. I have asked you to give me other examples that I can take into consideration when I sort of redraft it. But I'm appreciative you brought that to my attention.
Yeah, and I'm pleased to provide those examples. Thanks, Minister.
Thank you.
Thank you. Before I get to my questions, I'll just rule on those 2 points of order. In regards to the point of order put forward by the Honourable Stephen Lawrence, under procedural fairness resolution, committees must attempt to keep adverse reflections confidential or... sorry, I might come back to that one. But the advice that I've received from the Secretariat is to refer members to Procedural Fairness Resolution number 13 and to tread extremely cautiously. It appears that there is nothing explicit in the public domain in regards to this issue. There is a media article, but even the media article itself would only be one consideration of the committee going forward. So just to remind the members to be extremely cautious about questions in that space. In regards to the point of order from Mr Whitworth, no questions outside of the public citizen's right of reply should be asked, and I remind members to be extremely cautious that even though the substance of their question may be based on a public document, to ensure that there are no aspects within that question that fall outside of that as well. Thank you. Morning, Minister. Did you see the article that came out this morning in regards to Port Stephens Council Pound?
No.
No? Can I give you a copy
Sure.
of it? Thank you. I actually wrote... Thank you. I actually wrote to you about Port Stephens Council and the concerns that have been raised with my office as well. The concerns have been raised with me as from whistleblowers that the council pound hasn't been complying with the Act and have euthanised animals within the pound without proactively working with rescues as required under Section 64B of the Companion Animals Act, which, you know, we changed fairly recently. Have you seen my letter at all, if you haven't seen the article?
I'm just looking at it now.
Yeah.
Yeah. The pages have been sort of reversed. So just...
Oh, sorry.
Oh, it's both sides, that's me.
Do you know if you received the letter that I'd sent you?
Sorry, Chair, can we just clarify, was that a letter to Port Stephens or a letter to the Minister?
Both.
Okay.
We...
Yep.
I can give you a bit of...
So it's an assertion that at the council pound animals are being euthanised unlawfully, is that...
Yeah, so the concerns that have been raised with me is that apparently rescue groups can't even get through on the phone to the pound, in some cases the pound may not be giving animals a chance to be taken in by those rescue groups before they're euthanised, and allegations as well that dogs are being euthanised in the food preparation area at the facility as well. So this is the first that you've heard of this? Since
It's the first I've heard of it. That's a POCTA issue, or is it our issue?
This would be, I mean, if the animals are being euthanised in a way that would create a concern about cruelty, then that would be a POCTA issue.
That's not what the complaint is. Yeah.
But that, I'm answering the Minister's question there. If the way in which the pound is being managed is your concern, then that goes to how council is organising and managing itself. I'm aware that the council has provided certain statements to say that it doesn't believe that it is infringing or the POCTA Act or creating a problem, or that its management of the facility is in its mind appropriate. We're aware of it. I think we've only just been made aware of it as a result of I think you did make contact last week, but we're still trying to find the letter. But we're certainly aware of the statement, and we've also been in contact and had contact with Port Stephens Council as well, and that they are disputing, as I said, that there is an issue.
What's the actions then going forward? I mean, if the council denies that this is occurring, and at the same time rescue groups can't get access to these animals in contravention with Section 64B of the Companion Animals Act, I mean, you've got sort of two groups saying one thing and one group saying the other. I mean, what are the actions that the office can then take in response to that, given the claims are still coming in from rescue groups that they are offering to take these animals and are unable to even get an answer on the phone?
That I need to get advice on. I don't actually know.
This goes to a issue around the powers of the Office of Local Government that we would need to exercise wouldn't come from the Companion Animals Act, because it doesn't have that regulatory power. It would have to come from the Local Government Act. And so we would need to utilise power to obtain information, which we can do as preliminary inquiries, or we can commence investigations. And if there is a concern and that leads to a need for action to be taken, then the Minister does have powers to issue a performance improvement order. But I think on this we would need to be relying on advice and assistance from others in terms of whether there was a concern. We would need to interview the council and understand its perspective and, you know, potentially look at its procedures and processes, and probably take advice from whether it's the Animal Welfare League or the RSPCA on whether they believe that the pound is being managed in a way that contributes to the prevention of cruelty to animals.
Thank you. What's your response to these allegations, Minister? I understand that the Pound's denying them, but I can't imagine that these rescue groups are simply making up these concerns. What's your response as the Minister?
Well, I'm really disturbed if animals are being euthanised and mistreated unlawfully. Very disturbed.
And can I sort of get an assurance from you that you'll investigate this matter further as
Yes.
part of
In
your
fact,
office?
in fact, I'll request Mr Whitworth to ensure that we do that promptly right now.
Great, thank you. And can I, even if it's not this afternoon, but at some point later, get an update from your office in regards to the outcome of what's happening with that investigation?
I'd be happy to.
Thank you. And also, Mr Whitworth, I don't know if you can provide this to me by this afternoon, whether the office has taken any other sort of steps to look into this further from the letter that was received last week, or sort of what early steps. I understand you've contacted the council, but sort of any other steps that may have already started to action.
Certainly, Ms Hurst, but we need to remember that there are certain procedural processes and fairness that need to be followed. And the council is denying that there is a concern. So we're, the normal course of action that we would typically take would be to ask the council if this is a person that used to work, then there is potentially other mechanisms for them that would then need for the general manager of that council to take action and look at that as well.
My understanding is there's several whistleblowers, so I think that there's rescue groups that are being locked out, and then potentially people who have worked at the Pound as well that are all speaking out together. So that's why I have quite substantial concerns, and even further concerns that the council simply denying it rather than engaging in conversations themselves. But we'll continue talking about this, I'm sure. Minister, the first round of companion animal grants has just been distributed to rehoming organisations. I'm sure you're aware of that. Unfortunately, many rehoming organisations did miss out, and the vast majority received less than 50% of the money that they requested. You've spoken in the past about the important work that these groups do, and it's clear, obviously, this isn't enough funding for them to survive and continue going forward. I'm just wondering what your next steps as the Minister will be in this space.
Well, I mean, I had 6 million, I think it was 1.5 million I allocated. And I tried to allocate as much as that 1.5 million to as many organisations as I possibly could, so I could have as wide a impact as possible. So that meant that some of those organisations didn't get what they were asking for, but it was better than few not getting it. So it's just a matter of me continuing to ask government to allocate funds for those organisations, because rehoming is becoming more and more pressing, and so ultimately the argument I make is to government is that it's actually cost effective to fund rehoming organisations, because it avoids considerably more cost later. So I say that for the economic rationalists, but in reality I think it's true.
Yeah, thank you. So will you be sort of advocating then, I guess, to match the investment made by the former coalition government, which I think was 5 million over 1 year instead of 1.5?
I will continue to argue for increased funding for rehoming, because otherwise we're going to reach crisis levels.
Thank you. The opposition. The Honourable Nicole Overall.
Thank you. Thank you, Chair. Good morning to you all. Minister, if I could briefly go to the Code of Meeting Practice as well. Good to see it's finally introduced. And I do echo Dr. Con's concerns about much of what she has raised. And I am glad that you are prepared to revisit it, and hope that you'll properly take on board the genuine and valid concerns being raised, particularly the disproportionate effect on regional and rural councillors, not least the vastly restricted opportunities to attend by audio-visual link. Also, timing of meetings, and meetings being extended for exceptional periods of time. So coming to that, and also referencing, I'm more than happy to provide the many, many examples that have been provided to me on issues around all of this as well. But can we also ask for you to table how many complaints that you and the OLG have received about it thus far?
Yeah, look, I'm happy to. I'm happy to do that. I mean, what I've effectively got was some items of correspondence. It's often raised with me because I move through a number of rural councils throughout the state. I often, some of the things are raised with me orally.
Yes, but
It's one of the reasons I spend a bit of time in, try and spend a bit, not enough, in rural New South Wales, is to get an
Good to hear.
understanding of the pressures that they're under.
very good to hear, Minister, because of course your council experience is extensive, but it is Sydney and metro based.
Exactly
So that
right.
would be great if you can do that. You also just made a statement in relation to the element of only being able to attend by audio-visual link in, pretty exceptional circumstances. You used the word that some of your concern about the facility to do so was being abused.
Yes.
Was the word that you used. So is there evidence of that?
Well, I'm aware of.
So just anecdotally then.
Well, I'm aware of one because there was a specific complaint which has been verified in relation to its abuse. So I'm aware of that.
One instance.
Well, I'm aware of one instance, and I'm also anecdotally aware of what's been occurring in relation to it.
Okay, so would there then be, if that's just anecdotal, do you have analysis, evidence that you're also able to table that's a little bit more concrete as to the reasons why, particularly in relation to this audio-visual link and non-attendance in that, was reached? Is it based on evidence and analysis?
I think it's I could have a look. I mean, it's effectively based on upon experience, really.
Experience. So it's kind of like the vibe.
And knowledge of the sector.
Okay, because I'll now point on that basis, Minister, to a letter from Mr. Whitworth, and I'm happy to table that for you, but I just want to reference one paragraph. It was to the chairperson of the Northern Rivers Joint Organisation, and it states, and it's in reference to concerns that were raised by the Northern Rivers in writing in relation to the new Code of Meeting Practice. And Mr. Whitworth states in his third paragraph, the restriction on councillors' attendance at meetings by audio-visual link is based on one of the key policy principles that have informed the changes made to the Model Meeting Code, namely, to ensure meetings are conducted in a dignified manner befitting to a chamber of democracy. The intent of the Model Meeting Code, as with all the reforms of government is undertaking, is to uplift local government and elected councillors to ensure that councils act as and are seen as the legitimate third tier of government. Minister, how on earth does being able to attend by Zoom preclude councillors from being seen as acting with dignity or legitimacy?
Well, firstly, I'm quite impressed by Mr Whitworth's views because they encompass
Well,
mine.
I'm
and
unimpressed.
I couldn't express it that well.
And so are councils.
It's a bit like this, Ms Overall. We tried Parliament by remoteness. That didn't work too well. It didn't do much for the dignity of Parliament. Councillors aren't boards of directors. They're effectively elected representatives who need to attend a democratic forum and show up and accept responsibility.
And I think that most councillors, the vast majority of councillors, do show up and do take their duties and responsibilities incredibly seriously, and do so in a manner that is with dignity and integrity. Of course we know the examples. You and I both know the examples where that does not occur. But to penalise the vast majority because of a select few without giving proper evidence and analysis when it comes to a disproportionate effect on regional and rural areas in particular isn't good governance, Minister.
Oh, I think you're being a little harsh, Miss Overall, but I do concede that as I did concede to Dr. Conn when she raised it with me, that there are matters that have inadvertent consequence that I didn't consider at the time.
Okay, thank you. And I know that you're going to take that on board, so I just wanted to point that out.
I'm prepared to address it, but
thank you.
I know how councils operate. I know that.
I know you do, Minister.
That they can be involved in the debate in respect of something. A lot of matters get passed to them informally during a meeting. Somebody may not have considered something. It's very difficult to do that online. So, but I do accept that there are consequences, particularly to remote and rural councils, that I didn't consider, and I'm prepared to address them.
Thank you. And in that consideration, could I also ask that you may, and perhaps you may have given consideration to this, I hope that you would have and will into the future, because in trying to compare local councillors to state or federal MPs and the comparison with how we do business here as full-time salaried legislators, if you really want local government to be treated as the third tier of government, as they should, and you know that we're in agreement on that, have you given any consideration to reforms to councillor remuneration to reflect the workload and expectations being imposed?
So, the answer is yes.
I'm sure they'll be very pleased to hear that. But are you going to do anything about it?
Although I do regard being a councillor as civic service, as distinct from a professional function.
You also, if you do, then you can't expect the expectations to be the same.
What I have done to ensure a more high-level examination of their remuneration and what they're worth in relation to what their duties and responsibilities are, I have appointed as the chair, or recommended the appointment of the chair, Acting Justice Schmidt, who is also the chair of the Parliamentary Remuneration Tribunal, on the basis of
this will be looked at.
Having councillors' salaries looked at. There are other issues I'm going to speak to her and ask the tribunal to look at, which are matters that the councils currently determine themselves.
Terrific.
I think the same person who chairs the Parliamentary Remuneration Tribunal, who chairs the Local Government Remuneration Tribunal, is probably the appropriate person to get that into perspective.
Good to hear, Minister. Thank you. I'll be following that very closely.
Doesn't mean the councils will get what they want, but
doesn't mean that they'll get paid more. Is that a commitment? Is that an election commitment, Minister? Now, coming back to your previous points as well about saying no to behind doors briefings and meetings and that you're very against it. Can you confirm that now under your new code of meeting practice, a mayor may adjourn a meeting for any reason, even to consider matters offline, and then return with a recommendation for a vote?
I'm just trying to think about what circumstances that might even occur.
Well, I can take it offline with you and give you an example that I'm aware of that occurred in such a situation within the last couple of weeks. And if you're not aware explicitly on that, we can perhaps come back to it later in the day. But if that is currently the situation, Minister, then that wouldn't really be consistent with your other objectives about transparency and council decision making, and is the balance being achieved between a mayor's discretion to essentially go off and get a decision and come back, and the public's right to observe, would it?
That would be inconsistent, yes.
So it would be something that you'd want to have a look at if
Yes.
that is actually the case.
Yes.
Mr Whitworth, is that the situation as it stands right now?
Ms. Overall, I'd be keen to get a better perspective on the circumstances.
Sure.
If it's an issue arising out of an act of disorder, then that's certainly
I don't
something
believe-
that's possible.
No, not out of
So
not
I
out
suppose
of disorder.
context
I can definitely
here is
provide
everything.
you further details.
Thank you.
Okay, but something that if it's, again, another of these unintended consequences that may need to be looked at more closely. That'd be great. Thank you. Now, coming to the next aspect from the Code of Meeting Practice, the Code of Conduct, Minister.
Yes.
So you declared on the 5th of September 2024 the Code of Conduct system fundamentally broken. It still seems it's very much broken, examples of which we were seeing again just last week. You previously mentioned this morning that you don't have a role, and I'm presuming you mean in determinations, but you do have a very significant role in reforming it, for one thing. But if the submissions on the discussion paper closed on the 15th of November 2024, 15 months ago, where are things at now in terms of concrete implementation?
Can I say to you, as overall, and I've tried to get this message across before, is that what's generally referred to as the Code of Conduct is councillor, is a regime to control councillor
I'm aware of what the Code of Conduct is, Minister.
which forms a number of parts, not just the model code.
Minister, the question is 15 months.
But I'm so firstly, giving guidelines on freedom of political communication that overrides any other statutory documents to stop all these squabbles about people arguing about various regulatory provisions. That's been done. The Code of Meeting Practice that controls councillors'
Which you've now
conduct and behaviour,
implemented, yes.
that has been
Finally.
completed. The provision to enable serious misconduct, as distinct from the provisions contained in the Act, is contained in a bill that's currently before the Legislative Council, and had that bill been passed, this issue to which you refer would no longer be an issue.
So can we...
And so the legislation is pending in that respect. In relation to the model code of conduct, that document is pretty well drafted. I wanted to take the councillor
It'd want to be
declarations
drafted after
of
all that
interest
time.
provisions and do that by way of regulation, but the Act under section 440 AAA doesn't allow me to do that. So I have to put the declarations of interest provisions within the model code.
So do you have a timeline of when you would like to see it fully
I'm
legislated
waiting
and in place,
Right.
Minister?
Because I have to put the provisions of pecuniary and declarations of interest within the model code because the Act requires me to do that. I want to put the same provisions in the code as contained in the constitutional regulations that MPs have just been briefed by Minister Graham on. So I've been waiting for that to be completed, and I'm waiting for the Privileges Committee of the two houses to deal with the provisions in relation to immediate family disclosures, which I'm anticipating them doing reasonably quickly. I have to put those in the model code
So you don't
because I
really have
no
any
provision.
time frame right now?
So I'm waiting for the Privileges Committees of the Legislative Assembly and Legislative Council to complete that work. I've divided the code, the model code, between staff and councillors. The ones for staff of the council have gone to the local government New South Wales, and to the USU and the other unions and associations for their input, because that's more of an industrial relations function. So the completion of it, hopefully, if the Privileges Committee of the Houses move quickly, can be done within the next month or two, but effectively the other parts of the code are pretty well done and drafted.
So not too far away. So you're telling me shortly?
Not too far away.
Reviews
And
shortly. Labor's
there is
favourite
there is a white paper that's shortly going to go to Cabinet in respect of the changes to the convoluted process that currently exists through the Office of Local Government, establishing the Local Government Privileges Committee for minor misconduct matters. So it's all coming together now.
Shortly. Thank you. If only the answer was the same. The OLG received 4,289 complaints over 3 years and took action. I want to get to what the extent of that action is as well, against 14 councillors. What's the estimated total cost to councils of processing these complaints, including external investigations, legal fees and staff time?
I've got that number.
And also, of those 14 councillors, how many have been or were suspended?
I've got that number too. I'll go
Good.
look it up for you.
Excellent. You got a quick one that you might want to jump in on for a minute, because I don't have, I've got this other extensive stuff, so maybe just have one ready for a minute. Okay. Unless he delays excessively.
Gee, how many dog attacks I've got.
That's okay. You can come back to me.
That's all right, Mr Whitworth, give it to me.
Excellent.
The OLG received 1,801 complaints
In what period is that?
about councils, financial year 24-25.
1,800.
1,564 complaints were declined. 40 complaints relate to pecuniary interest. 40 relate to misconduct other than pecuniary interest. 3 complaints resulted in the commencement of misconduct investigations. 124 public interest disclosures were received. 8 matters were referred to the OLG by ICAC under Section 53 of their Act. 1 matter was referred to NCAT. 1 councillor was dismissed and disqualified. 2 councillors were suspended. 1 councillor suspended 3 times, so there's a pending appeal. I think you know that is. And 1 councillor was referred to NCAT, and you would know who that is.
I do indeed.
Can I just add the suspension? So any time we have a disciplinary action that involves a suspension or a reprimand, we put that action on our webpage.
Okay, but obviously they're few and far between.
And the total cost of code of conduct complaints
Yes.
against general managers and councils was $1,770,728.
Okay, great. Quickly, I've just got 25 seconds left, so one more quick one, please, Minister. You proposed giving the OLG expanded investigation powers, including penalty infringement notices. Is that occurring?
I just can't remember what's going into the white paper. Certainly, the fines are provided for in the bill that's before the Legislative Council at the moment, to allow the Land Environment Court to impose fines.
Yeah, that's fine. Yep.
Thank you. The Honourable Mark Latham.
Yeah, thank you, Chair. Minister, previously at this committee, and it was a very important point for you, you've told us that you first became aware of the NCAT listing about the Office of Local Government Action against Bill Saravinovsky on the 23rd of April 2024. That's right, isn't it?
I'm going to adhere to what I said before, Mr Latham. Whatever I've said and I adhere to in view of the fact that matters are before the court and pending. I'm not going to embark upon providing any more. I refer to previous evidence that I've given.
Okay, well, you've said that you first became aware of the NCAT listing. The first one was on the 23rd of April 2024. Yet the PAWC inquiry into this matter wrote to the Attorney General, Mr Daly, who wrote back to us on the 21st of November last year. He told us, citing the NCAT Principal Registrar, that there was no April listing of this matter. The first one was on the 8th of July as the Bayside Labor pre-selection nominations were closing. Minister, how do you explain this discrepancy?
Without departing from answers, the previous answer I've given you, I wrote to that committee relatively recently and corrected that misunderstanding. I refer you to that letter.
You wrote to the PAWC?
Well, whatever committee wrote to me in relation to a similar question, I've written to that committee to...
But you've refused to give evidence to that committee. What's the context of your letter? And can you explain it to this committee here, how you several times, multiple times, relied on the 23rd of April 2024 as the NCAT listing when no such listing exists?
Mr Latham, that's not right, but I refer you to the letter that I wrote a week or two ago to that committee, but I understand...
Yeah, well, that's so recent, we haven't seen it. Can you tell us what's in the letter? Why all these tricks in your evidence?
No trick. I thought the work of that committee is supposed to be confidential, isn't it?
No, there's a letter from your Attorney General, matters that have been on the public record, a matter you relied on the public record on the 23rd of April 2024.
Mr Latham, I refer you to that letter and you'll find that my recollection is accurate.
But how do you square your recollection that you saw a listing on the 23rd of April
2024,
can I finish, that your Attorney General says doesn't exist and the NCAT Principal Registrar says does not exist?
Mr Latham, I refer you to that letter.
Well, what's in the letter? I haven't seen the letter.
Well, then I would ask the committee of which you are a member to go and look at that letter, and I think you will find that my recollection as to the chronology is accurate.
Well, how can you say that when your own Attorney General and the NCAT Principal Registrar says there's no such listing?
I'm sorry. I can't comment on what somebody else might have told you, but I have written to you, written to the committee, I have advised the committee, and I just say to you that my recollection has shown to be accurate.
Minister, the citizen's right of reply by Mr Whitworth, your principal local government officer, goes to your integrity and credibility. Why haven't you read it?
It's not my concern. And I don't accept the premise of your question, really.
Well, you haven't read it.
Well,
and I'm telling you it does, and this is just another trick of yours to avoid answering questions, isn't it? You'd rather be ignorant of matters raised about your integrity by your chief officer than to answer questions here.
I don't accept the premise of your question, Mr.
I'm sure you don't. Minister, can we go to veracity of the answers you've given here previously? Did you sign Joe Jansen's nomination for Labor pre-selection in Ward 2 of Bayside Council in 2024?
I don't know.
You don't know?
No.
Can you take it on notice and go have a think about it? Did you sign Joe Jansen's nomination for Labor pre-selection in Ward 2 of Bayside Council in 2024?
I don't know.
Well, given that you did, and you were supporting her return to council, do you recall her ringing you several times the night before the pre-selection? You didn't answer those calls, and your supporters didn't vote the next day. Why was that?
I don't accept the premise of your question.
You're saying you weren't supporting her. Your previous evidence here, under oath, was that you had no involvement in the Ward 2 pre-selection. Do you stand by that?
I adhere to the evidence I've given previously as being accurate.
Minister, we've all been bemused and to some extent horrified by your conflicting evidence about the Saravanovsky matter, telling this upper house committee that you tried to stay out of it at the Office of Local Government, while telling the Legislative Assembly question time that Saravanovsky was so corrupt that you had to get involved to get rid of him for the sake of good governance in Bayside. Which version is true?
I don't accept the premise of your question.
In what regard?
It contains facts of which I reject. If you have a question, ask it.
Yeah, well, it's a question.
If you have a question...
The Sydney Morning Herald, in stark terms, chronicled your varying evidence here and the other evidence you gave in LA question time. Which version is true?
I don't accept the premise of your question.
In what regard?
In all its regard. It contains facts that are not
Your
accurate.
evidence today is that your evidence to this committee has been the same as in LA question time. Is that right? You think they're totally consistent?
I have given a consistent account to the best of my recollection, and I adhere to it.
Minister, it's very likely that the Upper House Committee will refer you to ICAC for abuse of ministerial office in the Saravanovsky matter. What defence do you think you could muster given repeated misleadings of the Parliament, abuse and intimidation of a public servant, ignoring his advice about propriety matters, and clearly involving yourself in an issue to achieve a local government outcome for the Labor Party in Bayside that you shouldn't have been involved in the first place?
I reject the premise of your question.
In what regard? What are they, among those things, what is it that you haven't done?
The question contains conclusions of facts of which I reject.
You believe you haven't abused your ministerial office
Yes.
in this matter?
I have not.
You have not? Is it true, as you told the Legislative Assembly, that Saravanovsky was so corrupt you had to be dealt with severely? How did you react to the news on the 4th of November 2024 that the acting head of the Office of Local Government, Danny Lester, had agreed to a plea bargain with Saravanovsky and all he got from NCAT was a tap on the wrist? How did you respond to that, given what you told the LA?
It's not a subject matter that I can actually go into without infringing section 111, 112 of the ICAC Act.
Oh, that's rubbish, and you know it. That's complete rubbish. You're a disgrace.
Order.
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 Well, it's right.
Order.
It's
I would like
complete
order. I would like the member to please.
Okay, I'll withdraw that.
Thank
Minister, what response did you make to the Office of Local Government and Danny Lester when you found out on the 4th of November that Saravanovsky had got a tap on the wrist at NCAT?
I can't answer that question because of the provisions of section 111, 112 of the ICAC Act.
Minister, do you acknowledge that you're in deep, deep trouble and have no right to stay in ministerial office, given the multiple improprieties you've conducted in this Bayside matter, which extends to the absurdity, the bizarro world reason why you don't answer questions at this committee? It's an admission of guilt, isn't it?
I reject that. Mr Latham, at some point, all this material will become available to you and other members of the Legislative Council, and I will be relieved of the burden of knowing what I know, but at this particular point in time, I just say to you, Mr Latham, if you are genuine, and I know you for a long time, you can be, and you're not wrong in pursuing the matter, you're just wrong at your conclusions.
Am I?
I just say to you, just do what the Chief Commissioner has asked you to do, just be patient. And then all will be revealed.
Minister, isn't it true you made no reaction to Danny Lester about the tap on the wrist?
I can't
you
confirm
said nothing
or
about it.
I
You
can't.
told the LA that he was so corrupt, but then you did nothing.
I can't
And he got a tap on the
confirm or
wrist.
deny anything because of the knowledge that I have and because of the orders that are made.
Minister, isn't it true those orders are about matters that are totally unrelated to Joe Jansen's nomination form or Bill Saravanovsky at NCAT? That ICAC was involved in a surveillance activity about Saravanovsky, upon which they took no action, but at a private examination, he's alleged to have told untruths, and that's the nature of the DPP. So you're just hiding behind that, aren't you?
The answer is no, and I can't confirm or deny any material because of the nature of the material that is provided to me and that I know of. But I just say, Mr. Latham, just be patient. We will all unfold, and I don't say don't pursue it. I'm pleased you are pursuing it, but just be patient and just wait.
Yeah, okay. Well, I've been around a while too, and I know what's going on here. And Minister, you said you declared a conflict of interest. I suppose it's a partial conflict of interest in the Saravanosky Bayside matter relating to your wife working at the council. If that's the case, why did you get involved at all?
I have a responsibility, which I've articulated to the Legislative Assembly, to ensure that my agency acts efficiently, promptly, quickly, particularly when it relates to serious
Yeah, but
matters.
that's not answering the question. You declared a partial conflict of interest. Why did you get involved at all?
I don't have, I manage my conflict of interest as I'm required to.
Thank you. Dr. Amanda Conn.
Thanks, Chair. If I recall correctly, Minister, you've previously expressed your concern that the Code of Conduct is sometimes weaponised to limit legitimate communication of political views by elected people. Is that still your view?
Yes.
Do you agree that on the face of it, the online statements by Councillor Veitch at Randwick that were put to you earlier by Mrs McDonald, on the face of it, constitute constitutionally protected political communication, whether or not you agree with those statements?
You're asking me for a constitutional opinion of where the High Court may or may not go with the decision of New South Wales and Unions New South Wales. I'm not sure that's within my expertise. But generally speaking, if I put that matter aside, people have a right to freedom of political communication. An example of what's not freedom of political communication is that matter that Ms Overall knows about. That's beyond that. That right of freedom of political communication that is implied it overrides all these provisions in the Code of Conduct provisions.
Thanks, Minister.
Which is what has been the big challenge, because if you stick a provision in saying bring the council into disrepute, then you're trying to stop a councillor legitimately criticising a council officer, a council decision on the basis of some provision which is inconsistent with an implied constitutional provision.
Minister, in the context of a coordinated smear campaign by local Liberal Party supporters against Councillor Veitch that commenced in September last year ahead of the Randwick mayoral election, I would suggest to you that these complaints are not only vexatious but a quite offensive attempt to weaponise the events of December 14, and I know that's something that impacted you and I more profoundly than most members of New South Wales Parliament. There was even a petition calling for her resignation that was started on the 15th of December while people were grieving. Will the revamped Code of Conduct that you're preparing prevent these types of complaints and the leaking of these complaints for blatantly political purposes?
That's basically what I'm seeking to achieve by doing that. I just say with Councillor Veitch is that I've known her for quite some time. She can express some extreme views at times, and there's certainly views I don't agree with, and sometimes viciously agree with. But she's actually quite a nice person, and works hard in that council area. And so I'm sure she regrets the position that she created, despite views of hers that I might passionately disagree with, because she's not one that openly seeks to... She's not of the nature of a person that would openly seek to create community disharmony.
Thank you, and I agree with your praise for Councillor Veitch. Sticking with the Code of Conduct, should a serious charge against a councillor of a nature that could put vulnerable people at risk. So, for example, a charge of sexual assault mean that a councillor should be stood down. Noting them, I mean, legal processes in these matters can take a very long time.
I mean, all these matters need to be determined on their individual facts and circumstances. You would need to be more specific. I mean, the problem with assertions of criminal conduct are that they would generally need to be, there's a presumption of innocence, and those fundamental bedrock principles have to prevail. If this legislation is enacted, for example, in respect of more serious misconduct, when I say more serious, misconduct that involves more than, say, 3 months suspension, then if the conduct constitutes somewhat serious conduct, then you could apply to the court. The court would have the ability to make interim, even ex parte decisions for suspension. For suspension, you can access a judge reasonably quickly in the Land Environment Court. So, reasonably quick remedies for serious conduct would become available, and would not just be relegated to the OLG to take it. I mean, the biggest criticism that I've had in respect of all of these, and I've got to say, I can take this opportunity, probably unfair. I mean, as of June 2024, the Office of Local Government had 45 people. Now, I managed to get them 37.2 million. They're up to about 100 with an establishment of 120. They had virtually nobody. They had a reformist minister demanding they move quickly on everything, demanding they move quickly. When I look at the list of achievements over the last 3 years, about what 45 people have done is quite remarkable. But despite all of that, for these serious matters, this is why other people have access to the Land Environment Court. So we're no longer subject to just waiting for the OLG to decide whether to take proceedings of matters of some seriousness.
If I can put one specific example to you, the one that was brought to my attention was a councillor at Weddenshire Council.
Which
Wedden, who's been charged with 3 counts of sexual touching without consent.
Yep.
These legal processes take a long time. We do have a legal system with a presumption of innocence, but this is someone who holds a position of significant authority and trust in the local community as a councillor. I mean, I would suggest to you that it brings the sector into disrepute to have people continuing to serve with those kinds of charges, specifically, potentially put vulnerable members of the community at risk. Should people with facing this kind of charge be stood down while that process plays out?
I don't know. I mean, we sat here with Gareth Ward until he was eventually locked up. It's very
and
hard.
I'd suggest to you that wasn't in keeping with community expectation either.
It's very hard. I mean, either there is a presumption of innocence and proof of guilt beyond reasonable doubt. Either you live with it or you don't live with it. To try and impose other standards on top of the presumption of innocence is difficult. If someone's under any threat, there's provisions under the Bail Act to seek to protect people. But I'm just loath to contemplate when there are other mechanisms to protect people, an interference with the presumption of innocence and the interference with the democratic fabric. What happens if the person is acquitted? They're presumed to be innocent.
Oh, the question was about whether they should be stood down pending the proceedings, not sacked altogether. But do you not think there's a different threshold for criminal sentencing and holding a position of significant authority and respect in a local community?
I think it's a difficult concept, Dr. Conn, and I'd have to think about it without giving an off-the-cuff answer. It's really hard for somebody who's been a lifetime in the criminal justice system to sort of act contrary to the bedrock principles that society operates under.
Okay. I'd appreciate you giving some thought to it, because
Okay.
it's obviously not in keeping with the expectations of the people in this community who've contacted
Yeah,
me.
well, there are plenty of things I don't like that you just have to put aside because that's part of what you've got to do, I suppose.
Minister, can I come to a different council? I understand that the Office of Local Government visited Clarence Valley Council recently. What was the result of that?
Can I say firstly, Clarence Valley Council hasn't conducted themselves unlawfully, improperly, broke any law, done anything that they were not entitled to do. If you look at the complaints in the last year or so, about a third of them are actually from the OLG received. About a third of them are from people from Clarence Valley, from effectively 2 lots of areas. And the matter's also been discussed with the local member as well. But because of the community disharmony, the Office of Local Government went there and spoke to various people. And I'll ask Mr Whitworth to take over from here as to what the current position is.
So we are, and I'll get Ms Hickey to elaborate as needed, but we are still going through those materials. I've made a commitment to go up to Clarence Valley. Unfortunately, I haven't yet managed to get up there. It's been quite a busy start to the year, but that's something that we're trying to timetable, and I know people are anxiously awaiting that outcome. There are a number of different processes that we can follow, from providing guidance and support to council through to more interventionist processes, but we'd have to have evidence for that, and that is what we're looking at the moment.
Thank you.
Thank you. There's about 2.5 minutes for the opposition. Yes, the Honourable Aileen McDonald.
I will just...
sorry, 2 minutes.
2 minutes. Aware of your ruling, but I'll just revisit Randwick Council. Can Councillor Veach be elected mayor while she is under investigation, and if comments are found to have breached the code of conduct? Or I'll reframe it, would Councillor Veach be permitted to run for mayor of Randwick under those circumstances?
Well, just because there might be some pending code of conduct requirement doesn't disfranchise her or the council from making decisions that are within their framework to make.
Okay. All right. Thank you, Minister.
So is she you obviously know, is she the next person up as part of the deal with Labor and the Greens, are they?
I believe so, Minister. Yeah.
Oh, okay.
And that would happen this year. Okay.
Saying the quiet part out loud.
Sorry? I might, Minister, during one of the last budget estimates, your questions about the incident where you bought a dress for a female tradie while serving as a minister. Since that time, have you given any similar personal gifts to workers connected to your portfolio?
No, I've received, though, gifts connected to the portfolio. I mean, somebody in Temora drew me a little cartoon and
Gifts you gave,
presented
not
it to me.
Gifts that you gave.
Quite good. It was quite good, yeah, I was impressed.
So you haven't, no.
No.
So after that incident was raised, did you seek any advice about whether that conduct complied with the Ministerial Code of Conduct?
No.
No? And did your office or department undertake any review or guidance following that incident to ensure appropriate interactions between ministers and workers?
I don't think there was anything wrong with it, really. I thought it was actually quite a nice gesture.
It's a nice gesture. But
Which I'd agree with.
Thank you. Look, there's just 1 minute for the crossbench. There's 2 minutes, 1 minute each. Okay, thank you.
Pretty desperate.
I'll just ask you a quick question. Order, thank you. In regards to the companion animal grants that we were talking about earlier, will groups who receive funding this year be ineligible when it comes to grants next year, or will priority be given to organisations that didn't get anything in this round?
I don't know, Mr Whitworth.
The short answer is those people that applied for a grant this year can apply for a grant next year.
But will priority be given to those that received nothing? So
Well,
their chances are potentially lower?
Ms Hickey?
Yeah, so we haven't done the, we're going to review the guidelines for round 2, and if the Minister feels like that's a useful thing to do, we will consider that. The other thing I should just say is that we'll offer a webinar for the unsuccessfuls and successfuls about how to fill in the application, so those that weren't successful last time. It was usually for a lack of detail. So
Thank you.
yeah. Amanda, did you want the other minute?
No. Mr Lakeland?
Yeah, thank you, Chair. Minister, you said that you've managed your conflict of interest on Bayside. How exactly have you done that?
I've written to the Premier to advise him that my wife works there. I've written to the head of the department to advise her. I've written to Mr Whitworth and let them know that my wife worked there.
And did you describe your wife working there as giving you a conflict of interest?
It was on the basis that they were aware. I can't remember exactly what was in the letter, but they were aware that she worked there.
But you'd have to assume that that was on the basis of a conflict of interest, and if so, how did you manage that interest?
I manage that interest on the basis that if I'm dealing with anything in relation to Bayside, I decide whether or not I deal with it or not, or whether I refer it to somebody else.
And how many times did you decide not to deal with it?
I think there have been a couple of matters that I've chosen not to deal with.
Thank you. We now go to government question time. Is there any questions from the government?
We have no questions at this time.
Okay, thank you. In that case, we will break for morning tea and we'll be back at 11:15.
don't write.
Thank you. Thank you. We are back at budget estimates, and I throw straight to the opposition.
Okay. Thank you. Thank you, Minister. I'd like to move to a quite a specific example, but which could have broader impacts for other councils on what appears to be an attempt to influence a council in the conduct of its business. This relates to another proposed regional renewable energy project that's facing strong community opposition due to what is expressed as a thoroughly inappropriate location in the Monero. And a Snowy Monero Regional Councillor was preparing a notice of motion to detail the community concerns and council's reservations on the proposal as well. Now, prior to that, just prior to the councillor putting forward her motion, all councillors received a self-described briefing note from the proposed developer, Sameva Renewables. Are you aware of, or have you seen that, what they refer to as a briefing note?
No.
Okay, I'll table that for you so that you're able to take a look. This apparent briefing wasn't sought nor requested by the council, and the language contained in it is, I believe, of serious concern in appearing to instruct these elected representatives as to the nature of their roles and responsibilities, including specifically declaring that, and I quote, approaching parliamentarians is a potential risk for council. So if you wanted to take a quick look at that, please, Minister,
I'll just read it.
and, point me to where in the Environmental Planning and Assessment Act 1979 does it prohibit a council from debating, forming or putting forward a position on a state significant development and or prior to an EIS. So, without the...
Just let me read the last paragraph on the last page, if you wouldn't mind. Yeah. Can I just say, at first blush, it's no more than an advocacy document. Is there something else that, beyond that you're concerned about? And so
yes,
forth?
I'm very concerned that of the view as expressed by Sameva that it's legally flawed for elected councillors to debate and vote on a motion about a project affecting their community. I think that goes beyond advocacy. I think that is massive overreach to the potential inference of attempted intimidation of councillors in order to fulfil their elected role.
Well, I don't know, Ms. Overall, I mean, some members of the community and corporations and stuff say far worse to councillors.
That's irrelevant, Minister. This is an official correspondence to councillors attempting to instruct them in their capacity as to what they should and shouldn't be considering in regard to a project that has considerable community concern. How is that possibly within the Act? Point me to then where it says in the Act that they can be suggesting that it's legally flawed or a risk to council.
Well, I don't think it is. That's my view. But I mean, if I was a councillor, having been a councillor and got one of these, I would have just treated it as an advocacy document. I mean, if it was going to influence me in any way, or I thought it might have been correct, you know, you may well have asked the council staff to write a report and analyse it for you before considering the motion. But
Well, I can say that the motion wasn't put forward, Minister. I mean, it could have been because of the time constraints. Again, one of the councils who are impacted by the new code of meeting practice. But you're suggesting that they should essentially just have ignored it and not worried about it, just get on with the business of council, that there's no ramifications for a private company.
Well, overall, the councillors need to make their own judgment. I mean, had they chosen, or a majority of them chosen to ignore it, it was open to them to ignore it. If they majority of them, or some of them, thought that perhaps, you know, the mayor thought that perhaps they should just get some advice. I don't know, how long before the meeting did they get this?
Look, I'm not entirely sure. Like within a couple of days, I think.
Yeah.
It was quite close to it. But you do, at least in your personal acknowledgement, that this would not be considered acceptable.
Oh, look, I think that's probably overstating it. I suppose that the difficulty is, I mean, because I'm a lawyer, I suppose I regard those things, you know, objectively and etc. I do concede, though, that to somebody who's not a lawyer and who's somebody who's just virtually not much more than a volunteer, particularly in a council like Snowy Monaro, where they've been living under very difficult circumstances, that they really don't need this. But you know,
I think it's pretty concerning, Minister, for these cowboy companies to come in and attempt to interfere, even if it's only a perceived interference in community concerns being lodged with their elected community representatives.
I just take it as an advocacy document. I mean, they want to be heard in respect of a matter they've chosen to do it this way. At least they've put it in writing, and they haven't started ringing up individual councils and harassing them.
Do you think that something further should come of this, that this should be looked at a little more closely by the Office of Local Government?
No, I don't think so. I think at this stage, you know, the councillors, having yet not made a decision, could ask their general manager or the appropriate officers to write a report to the council in respect of the matter. I mean, because they're alleging unlawfulness, I suppose, is that they are in a position under Chapter 4, Division 1, to exclude the present public and deal with it, you know, on the basis that it might relate to, you know, lawfulness, etc. But
I think that's a long bow, Minister, and I think that I'll stick to your previous
I don't
assertion
think it's,
that it is of concern, and clearly of concern to that council. But
I'm not overly. If it was something that I thought was really concerning, I'd say so. I just look at it as an advocacy document, and I would say to the councillors that you know, if you're in contact with them, is just don't worry about it.
Minister, if I can assist as well, I'm just looking at, I've grabbed the document off the Minister's table here. This is about a state significant development. So council's role here is to provide a submission as part of its role as the local authority, but the development is being assessed as state significant development. It's being assessed by the Department of Planning, Housing and Infrastructure. If there are a number of submissions, which is quite clearly identified, then it will be determined by the Independent Planning Commission. So this is simply someone seeking to provide advice to a council, but probably, you know, I haven't read it. I
suggest, Mr. Whitworth, that you might want to read a little more closely. And if I'm a councillor on that council, I would take a little bit more than just advice, and it's pointed. But anyway, I have other questions to get to.
Can I just say, look, Ms. Overall, I'll have Mr. Whitworth look at it in the fullness of time. If his view is any different to the very quick view I've expressed, then I, Mr. Whitworth, will let you know.
If we need to make clear to councils what their role is in relation to state significant developments, I'm happy to take that on.
Thank you. Appreciate that. Could we please move to financial sustainability?
Yes.
Now, in March 2024, you told this committee that you, and I quote, didn't think we can wait 12 months on council financial sustainability. 2 years later, The government has supported 15 of 17 inquiry recommendations, but as yet not enacted any legislation. So when will the first legislative change take effect?
Well, firstly, some of the changes, the first tranche of the changes have sort of occurred before that, and that relates to the IPART methodology of determining rate peg.
I'm going to get to the rate peg, Minister.
Yeah,
we'll just focus on the timeline.
Yeah, no,
this.
but it's relevant because it has provided for the sort of flexibility that they needed and provided for various path-throughs. So some of the pressure is off them in relation to financial sustainability. The other issue in relation to their sustainability relates to the financial assistance grants for the Commonwealth, and you would know all about that, so I don't have to go into that.
No. You're still advocating, I'm sure, for it too.
One of the recommendations related to the expert panel and to provide advice about the Council's financial systems and that methodology, which is a key part of its implementation. And that panel has recently been selected by the Cabinet, and that will shortly be meeting. So we're well and truly on the path of change, and the next tranche will be of legislative changes, although I'm not sure whether legislative changes are necessarily required, will be guided by that panel.
So it's shortly?
It's in a constant process.
In the fullness of time. Yes, Minister. Cost shifting.
Fullness of time. That's a Humphrey answer, isn't it? Yeah.
Yes,
in the
Minister.
Fullness of time, Minister. Yeah.
All things
Heard that
being
expression
equal,
before.
Minister. Cost shifting onto New South Wales councils has grown from $1.36 billion in 21-22 to $1.5 billion in 23-24. This is $497.40 per ratepayer diverted from local services. And of course, for regional and rural councillors with small rate bases, as you would know, the per ratepayer burden is even more crippling, and LG New South Wales identified Berrigan Shire in the Southern Riverina and Clarence Valley as among the hardest hit. So what specific action has the government taken to reduce cost shifting since you became the Minister?
Well, firstly, I assume you're pulling those figures from the Local Government New South Wales Consultants Report.
Yes.
Consultants Report. Mm-hmm. And I don't accept the premise of a lot of that report. And I have said to Local Government New South Wales that they need to identify with precision those issues that they particularly want me to address for them, rather than just complaining about stuff that is really either a pass-through or alternatively a historic function of local government. Now, having said that, Ms. Overall, I do not take away with the struggle and the fantastic work done with virtually nothing of most of the rural shires. But, you know, we are doing things like, for example, having IPART enabling effectively increases in the emergency services levy to be effectively a pass-through with rate peg determinations. We are enabling election costs. Firstly, 55% of them paid for by the state, but we're also having those incorporated into IPART's rate peg determination.
And still issues around that as well, Minister.
We've given them 252.2 million, you know, in apprenticeship programs that are fully funded.
I've got questions for that as well.
So,
yes.
But can I just say this? We whinge about the Commonwealth cost shifting. Local government, I know, since I was a kid, even probably before that, have whinged about cost
Because they're a
shifting.
pain? Is that
And so
the way you'd
it's
phrase
just
it?
it's just the normal tensions. But
No, Minister, no, I'm sorry. I beg to differ that it
Okay.
is not the normal tensions. Now, if you want an example, and yes, you're talking about the rate pegging there, and absolutely we should have that conversation as well. What about the emergency services levy subsidy that your government removed? How has that impacted councils and disproportionately impacted regional and rural councils negatively? Do you have the figures on that, Minister?
what do you mean removed?
Well, you discontinued the emergency services levy subsidy, did you not?
Oh, well, yeah, the subsidy was only...
That was in place under our government. You
Yeah,
discontinued.
well,
Let's just say you didn't continue with it.
Very reluctant to do this, but really, the Minister can't even get 2 words out. In fact, struggles to get 1 word out before he's cut down. So I just think the opportunity to sort of ask questions and hear answers is the best way to proceed.
Yeah, things are getting a little bit heated, so I just
Right.
want to remember. Thank you.
Yes, Chair.
The subsidy for the increase was a temporary subsidy that the former government provided that had run out.
That you
but-
didn't continue, Minister. He did
but-
finish, Mr Donnelly.
No, but what we did do, and that you probably find the sector's quite happy, is that we've got IPART to incorporate those ESL increases into its rate peg determination.
And I'm sorry again, Minister, to interfere there, but that in you saying that they'd probably be very happy. Again, do you have evidence of councils and local government New South Wales
Because
saying
it-
that they're happy with that outcome?
Because they've stopped complaining.
Goodness me. To give you some concrete examples, when the ESL subsidy was not continued, Tenterfield Shire lost 119% of its approved rate rise to the levy, meaning the ESL increase exceeded the entire rate increase. Burke lost 94%, Hay 88.6%, Yass Valley 96%. These are all regional councils. So what analysis did the government conduct before removing the subsidy and then deciding that IPART and the rate peg, which is still, what is it, ranging from 2.7 to 5.7%, is adequate?
I can have the analysis provided to you because it was analysis that was actually handed to us in April of 2023, being about the first thing that was given to us when we were sworn in, and that the subsidy had run out, and that this was going to be the cost. However, Ms. Overall, since that, so I'm trying to get to since that, we've changed the entire rate pegging methodology. That's why the complaints have probably stopped. So instead of rate pegs being determined in arrears, they're now forward-looking, and that the ESL increases that local government have to pay are incorporated in the rate peg determination. So, did it impact upon them severely in the first decision of the Minns Labor government that it had to make because of the size of the deficit? It did. Was there an analysis? Did we know how much it was going to cost? We did. Did we have to put tin hats on because of its impact, which we knew it was going to have? We did. And
Okay,
did we
Minister,
try and
thank you.
address it? We did that by trying to change the rate pegging methodology.
So changing the rate pegging methodology, can you, and coming to a different aspect of that in the minute that I have left, how many councils have applied for special rate variations for 2026, 2027?
I've got those numbers. I'll give those to you.
Thank you. And have you expressed that you want to return special rate variations to their original purpose?
Yes. Well, subject to this, and this is in the government's response to the financial sustainability.
Yes.
And that is that for them to apply to IPART for infrastructure works or something that they particularly want to fund, subject to community consultation, etc., to be able to rate peg to fund that. If they want to do it to increase their rate base, then they've got to go through a income and expenditure examination by IPART to ensure that they're efficiently undertaking their expenditure, so they actually need it. I know the bell's ringing, so I'll keep answering the questions so I can give you the answers that you wanted. So, which of the... All right, on the 17th of February, IPART have received 10 applications for SRVs ranging from 24.25% to 58.06%. One of those 10 applications included a transfer of the Central Coast stormwater drainage charge. And as part of that assessment, IPART have invited community feedback by the 9th of March on those applications, and I can tell you who they are if you like. You want me to tell you who they are?
Any regional councils in that, please, Minister?
All right, Ballina, 6% for 4 years. Their rate peg's 3.4%.
Sorry.
Blacktown are seeking 16.46 for year one. I know this City Council. Central Coast, 12.8% rate peg, but that's for stormwater drainage. They're moving for water rate bill charge because of change of legislation. Cessnock have asked for 39.9%. Their rate peg's 3.8%. Glen Innes have asked for 21.5%, 12% and 9%. Their rate peg's 3.4%. I've visited Glen Innes. They're in a bad way, but they're really doing really well trying to address their problems, although I know the OLG are worried about them. Hawkesbury, 8.66% for 4 years. I don't know whether you include that as rural. Muswellbrook, 29%, applied to mining categories only. And Uralla have asked for 28.5% for year one, 23% for year two. Their rate peg's 3.7%.
Thank you. The Honourable John Ruddock.
Thank you, Chair. Good morning, Minister.
Morning, Mr. Ruddock.
Under the Local Government Act, you do have there's two categories of when you have concerns about a council, you can issue a performance improvement order, or you can order a new administrator to the council. So for the more egregious dysfunction that could be happening, are there guidelines as to determine what's the difference between a performance improvement order and appointing an administrator?
Well, the power to appoint an administrator under the Act isn't available for me just to do, or for a minister just to do, probably rightfully so. So that you have to go through a process of undertaking an investigation under Section 430 of the Local Government Act. And the process usually involves a preliminary investigation, then a Section 430 investigation, and then a determination as to the minister has power to suspend a council for 3 months, with an extension for 3 months, but you can't sack a council in effect without a public inquiry.
But what about the performance improvement orders? That is something at your discretion, is that correct?
Yeah, performance improvement order is an order in which you can, if the council's not doing something that they're supposed to do, they're acting either improperly or unlawfully or in breach of some statutory requirement. There's a process whereby you can give them a draft performance improvement order, ask them to respond, and then make a permanent improvement order. If a permanent performance improvement order, if you make such an order and they fail to do so, there's a convoluted process of which ultimately you can then take some action. If you'd like it in some detail, I can give Mr. Whitworth.
Are there guidelines for what would trigger a performance improvement order?
Guidelines. Are there guidelines?
Minister, we have a procedural framework for performance and suspension orders, which is not a guideline for councils in terms of how they would behave, but they are certainly guidance to us on how we would go about getting a consistent approach procedurally to addressing a particular issue with the council and making a decision as to whether we would go performance improvement order or direct to a public inquiry. I would also just add that when the legislation was created to introduce the performance improvement order process, it was posited on the basis that it would be, I suppose, an escalation, and the point of being a regulator is to escalate the action depending on the severity of the issue.
So if I gave you an example, if there was a situation where the state government has agreed to give a local council some funding for disaster recovery for critical infrastructure, and then so you've given the council the money, then the council doesn't spend it and returns it to you, and the infrastructure doesn't get built. Now, every other council I know is out there desperate for state government money. So would something like that, where it does seem like it's internal incompetence, would that be something that could trigger the considering of issuing a performance improvement order?
Minister, if you're happy for me, I would say no. In fact, I think we have given evidence previously that we have actually asked for money back from councils where they haven't completed a particular project in time. And it would also depend on the nature of the reason why the project couldn't be delivered. We'd hate to see something half built. If the council is identifying that there is a reason why they can't complete that infrastructure, then it's actually probably beneficial to return the money so that we can provide it to, some other more, deliverable project.
Well, then could I bring up the example of the flood-exposed strategic planning in the Hawkesbury? Now, we know that there's been floods there forever. Has there been any consideration in the Office of Local Government that there needs to be closer ministerial supervision of what's going on there?
Sorry, Mr. Hoenig, but that's sort of confusing the role of the Office of Local Government with the role of planning under the Department of Planning, Housing and Infrastructure. I do know a lot about flooding in the Hawkesbury, but that's because I was previously a Deputy Secretary in Planning. I'm not sure what the question is in relation to council administration.
Okay, well, I understand that funding was provided, but then it was returned because it just wasn't delivered. Now, the locals, I understand, were very keen to have that funding delivered, the flood mitigation. But then the locals are very upset because it's not happening because the money's been returned to the government. But if I could go back to the Minister, if a council has not progressed a comprehensive local environment plan update for more than a decade, would that trigger any type of concern within your portfolio?
The concern would be a planning concern for the Planning Minister. I have had discussions with the Planning Minister about how we can use provisions under the Local Government Act to encourage councils to be more efficient and effective in respect of their planning work, because whilst the Planning Minister controls the Environmental Planning Assessment Act and the provisions they're under, their only power other than that, apart from removing matters from the council, is appointing a planning administrator. So I've had some discussion with the Planning Minister because through my work, for example, in meeting and visiting councils and dealing with them in terms of their management and administration, I'm coming across examples where some really switched on general managers have come across solutions to reduce substantially development application delays. So I've had discussions with the Planning Minister and I know Mr Whitworth has also been having some discussions with some general managers about ways in which we can formulate a management structure that can aid the Planning Minister and the efficiencies of councils dealing with DAs. There's some really clever examples that I've come across as I've moved through, particularly rural New South Wales. They're the ones that seem to do it really well.
So, Minister, if there is a council with a pattern of returned funding, delayed statutory planning, contested executive appointments and stored resilient infrastructure, at what point does the office determine that systematic governance intervention may be required?
I think the test would be that probably if they were so hopeless that that there were such major failings that would require us to do something, that there would have to be at a pretty high bar, I think, Mr. Hoenig, because they are the third tier of government. They are democratically elected. If their performance is poor, it's for the public to judge and replace them. So I've been actually trying to get the state out of local government affairs, and I've been trying to depoliticise the approach. That's why most of the reforms that have taken place, nearly all of them over the last 3 years, have been done on a bipartisan basis, not only with the support of the opposition, but usually improved by the opposition. So, you know, I'm reluctant to, whenever I or the OLG interfere, it's not political, and it's because we have to, or there's been some statutory breach.
Has Hawkesbury City Council been subject to any formal performance monitoring in the last couple of years?
Not that I know of. Do you know, Mr. Whitworth?
No.
There's something on my list.
I mean, we can take on notice whether we have made any preliminary inquiries with that council, but it's not subject to any Section 430 investigations. So I don't. Sorry, I've been reminded by Ms Hickey that there is a particular councillor that has been suspended from that council because of a criminal charge that they are currently facing, which related to their function as a councillor.
Thank you. And look, my last question is, if there is a council where everything's working fine except that the planning functions are persistently delayed or impaired, does the Minister have the power to appoint a planning administrator?
No, the planning minister has power to appoint a planning minister.
I see. Okay, thank you. Thank you, Chair.
Thank you. Minister, if I could return to the companion animals grants.
Yeah.
So one group received just over $5,000, which would cover less than 3% of the organisation's vet bills alone from last year, let alone the costs of actually housing and rehoming those animals. I'm just wondering, given that this falls under your portfolio, I mean, how do organisations like this continue this vital work without enough finances to do so?
Well, because these fabulous organisations just struggle because they're completely under-resourced and they operate by the use of volunteers. I concede that there's not enough. And Ms Hurst, we tried to spread the $1.5 million as much as possible to try and get it out to as many as we can, and I don't say it's enough, but it's all I had.
Mm. But you recognise that obviously 1.5 is significantly underfunded.
I recognise that, yes.
I mean, obviously,
and I will keep trying.
Thank you. Obviously, there's not just frustration from those organisations, but a real sense of anger around this. I mean, councils and state government are essentially leaving this work to these private charities and to these citizens to foot the bill on behalf of state government and local councils. I mean, what do you say to them if they were sort of listening in today? What you would say to them? Obviously, they're struggling. They know that we all recognise that the work they do is amazing, but how do they keep the doors open? How do they continue to the work that they're doing going forward?
Well, firstly, can I say to them, thank you for what you do. I mean, it's really impressive work, and the consequences of them not doing it would be just horrendous. And there is never enough money for anything, but there's, there's not enough. I'm going to ask for them to provide extra funding. I mean, the system operates the way it operates, even with the enforcement of animal cruelty effectively through non-profit organisations funded by the state. So it's the way in which animal welfare has historically occurred. But things are getting better, certainly getting better, I've got to say, than they were, say, a decade ago.
In what way, Minister?
Well, the way in which the reduction in euthanasia rates, the way in which animals are treated in pounds, the success of the rehoming organisations and their encouragement. I mean, I know that the Animal Justice Party can take the credit for actually moving government in respect of it, because without it, governments may not have moved at that pace. But it'll never be enough. And the decisions that we ultimately end up having to make in this space, whether they be grants or whether it be decisions on this new Companion Animals Act, there's always a balance, isn't it?
I just want to drill down a little bit on the reduction in euthanasia, and I know you've spoken a bit about how happy you are to see a reduction in the euthanasia. In previous estimates, we've talked about that. There's been a push from some councils and some advocacy groups for cat containment laws, and our inquiry into cat containment laws found that there was a significant increase in euthanasia in states that had allowed councils to bring in cat containment laws. Would you say that you would be very hesitant to introduce laws that would see those euthanasia statistics suddenly skyrocket instead of continuing in this downward trend?
So the rubber's shortly to hit the road, because the work that's been done in that area is shortly to hit me, and I have to take it to government. So I'm actually going to have to start making calls in that respect.
Would it concern you if legislation
and
was
I'm concerned
proposed?
about that decision. That's why I asked for that committee that you chaired to conduct the inquiry, and of course that committee was split in terms of its recommendations.
Well, it wasn't split. There was recommendations by a majority, and there was a couple of dissenting statements, but the majority had a whole variety of recommendations that still fell into that report, which is fairly normal for an upper house inquiry.
Look, I know that, and I accept the statistics from that report and from that most of the destruction of wildlife is not occurring from domestic cats.
Exactly.
Although domestic cats are responsible for the destruction of some wildlife.
That's correct.
So I'm really concerned that if councils have the power to provide cat containment, that firstly, I think the committee's report referred to equity matters, but you're referring to those people who don't have necessarily the resources, firstly. Secondly, what happens if an 85-year-old pensioner's cat gets out and a ranger turns up with some fine because her cat inadvertently got out? Now, I'm concerned about that. I know what the Victorian experience is, and they've got cat containment laws, but they're not enforced unless somebody complains about it, which is effectively legislating or providing regulation for the purposes of providing it just to appease people, as distinct from providing an effective regulatory mechanism. So, but the RSPCA have a different view to you. Their view...
No, actually, the RSPCA have the same view as myself.
What's that?
The RSPCA and I are on the same view on this one, and so the RSPCA is against punitive cat laws, containment laws, and so is the Australian Veterinary Association.
Because you'll end up with more cats in pounds, which are already full, I understand that. But even, see, whatever the government does with cat containment, we're going to empower, for example, councils to pick up stray cats like it can pick up stray dogs, which it can't do at the moment unless they're in food preparation areas. So that's going to increase the amount of cats going into a pound anyway. So, in any event, I get the issue. I haven't got a concluded view. It's been troubling me. I've put it off by giving it to your committee. I'm going to have to make a call soon. And there's no point whinging about it because people just say that's why you're the minister. So I'm
not asking you to whinge about it. I'm asking you, you know,
I know what you're
mentioned
asking
that,
me.
you know, and we've talked about it in previous estimates several times that
I just want you to
you're
know.
very happy to see a reduction in the euthanasia.
I just want you to know what my
proposals to
I just want you to know what my
increase
considerations are so that you got the opportunity of getting to me before I make a decision. Because I need all the help I can get. That doesn't mean I might agree with you, but I understand. I want to make sure that your views are properly considered.
Yeah, thank you. And the other, you know, there was equity issues. You know, the people that are most impacted by this are renters, for example, First Nations communities, people on lower incomes.
Yes.
But the other side of this, obviously, is that the inquiry heard that there was absolutely no evidence that these laws actually reduced the amount of wildlife that was killed because they can't be upheld, as you've rightly pointed out yourself now. So what we heard from councils in Victoria was that where they'd actually implemented these laws, they had so many complaints and they had no spaces in the already over capacity pounds, same problem we've got here in New South Wales, that they couldn't actually enforce them anyway. And the councils we spoke to said that the only way they can have cat containment laws is if they get a significant amount of funding from state government to be able to expand and upgrade their pounds and to be able to actually do all the work, you know, to be able to try to rehome these cats as per the section of the Act that requires it. So there's a lot of issues, obviously, with this that were raised within that report, but I'm assuming you're across that from reading the report.
Yeah, I am troubled though as to what I end up having to do.
Why would we do something if there's no evidence that it's effective and the report recommended that it's not the most effective way forward and there are other solutions that are being proposed by the Australian Veterinary Association and the RSPCA, for example?
Because sometimes in government you don't get it's not good enough to be right. You've got to take people, you know, with you on a journey, and sometimes you don't have the capacity or ability to, you know, to do that. I know what the difficulty is. I mean, it's going to be on my desk very shortly, and I'm seized with what I need to be seized with, and for those things I'm not seized with, I want to make sure you give, you and your colleagues have every opportunity of making sure you're heard. Some people think it's a magic solution, isn't it? You have this cat containment rule or regulation, and I've done it. You know, the solution is not always done just simply by legislation, regulation, doing a code and saying, I've done it, because if it's not effective, then what is it? A media statement, and it just doesn't, and then the problem's not resolved.
Yeah, thank you. I'll have some follow-up questions, but
Thank you.
Thank you,
Chair. I'm mindful of the ruling before with regard to, so I'll try and be cautious, but I wanted to follow up on some questions that the Honourable Mark Latham raised with regard to conflict of interest in the Bayside matter. So at the previous estimates, you stated that any conflict was managed. What precisely was that management plan?
Well, if I think that I can't bring an impartial mind and I'm the decision maker, or I risk not bringing an impartial mind, I might absent myself from the decision making.
And Was it a written conflict management plan?
I beg your pardon?
Did you have it as a written plan, this conflict management?
It's not a management plan. I mean, I'm required to disclose to the Premier where there might be anything that might lead to a conflict, and I voluntarily disclosed when I became Minister in writing to the head of the department, the head of the Office of Local Government, that my wife was the employee of a council.
Mm-hmm. And are you able to table any of that documentation demonstrating how the conflict was managed?
Well, their correspondence, I'm not going to table them publicly. She's entitled to her privacy, but if you want to see them, I'm happy to show them to you, but I'm not going to table them.
Might see it come to you later. Okay. Is it appropriate for a minister to involve themselves in the timing of disciplinary proceedings involving local government officials?
The Minister for Local Government is accountable to Parliament for the efficient and expeditious decisions made by their agency. And the public would expect the government to ensure that when matters are of a significant or serious matter, that the minister ensures that they act expeditiously, thoroughly, and promptly.
And so,
now, on those sort of matters, the minister has no role or no statutory role, is not a decision maker, but is certainly accountable to Parliament to ensure that that the agency moves expeditiously, quickly, and efficiently.
okay. And in ensuring that accountability, Minister, what safeguards are now in place to ensure, say, that live investigations cannot be subject to perceived political influence?
Well, there's no political influence because the minister's not a decision maker. But I can assure you, Mrs. McDonald, that there are a number of matters that get referred to the OLG where they have the statutory responsibility to make determinations, and I, when I'm told about them, they might advise me as to what the status is, and I might regularly indicate to them to get on with it. They're the decision makers. Because when you're dealing with, say, allegations of substantial wrongdoing, justice delayed is justice denied. The sector, the reputation of the sector is quite important and quite vital. You know, I'm really sympathetic to the Office of Local Government, as I think I said here before the break. I mean, you know, 30th of June they had 45 people. I mean, they're dealing with enormously difficult matters, but you know, at the end of the day, they've got to get on with it. I mean, I gave you the statistics before. I mean, they've got 7 matters referred to them by the Independent Commission Against Corruption, which, as you would imagine, are matters of quite some substance. And I say to them, get on with it. When it comes to allegations of impropriety by a councillor down the south of New South Wales, I tell them to get on with it.
Minister, can I just stop you there, because I'm going to come back to the Office of Local Government and staffing. I'd like to now turn to, say, staffers that are working as councillors, and I'll probably get you to take on notice to see if you can provide the committee with a list of all New South Wales government, ministerial and departmental staff who currently hold elected positions as councillors or mayors in local government. Would you take that on notice?
Well, I don't know how I would source that. Wouldn't know how to source that. I mean, I don't have anybody on my ministerial staff that is an elected person on the council, but
could you take advice?
But I don't know who they are. I don't know how the Office of Local Government and my office would actually find out. But in any event, why is it a significant issue?
It could be, yeah. Perhaps.
I don't get that, why it's an issue. I mean, you really want local government, don't you, to be made up of a cross section of the community, from people from different walks of life.
Yeah.
Just because you're employed by a minister shouldn't disqualify you from elected office.
Okay, then Minister, is there a policy, like a New South Wales policy, on ministerial departmental staff that simultaneously are serving as elected councillors or mayor?
Can I answer the question in relation to departmental staff? Obviously, public servants have as much right to be a representative on council as anyone else. Any public servants in my department, and I can only speak for my own department, who do stand for local government election would need to declare that through secondary employment forms, and also to have a conflict of interest management plan.
Okay. And are staff in ministerial offices or government departments required to take leave from that role when performing official council duties, such as council meetings, mayoral functions or committee work?
Well, I don't know. If they conflicted with their time when they're supposed to be at work, they'd need to provide whatever leave requirements that they need to provide.
That would be part of managing secondary employment. It's the same as anybody else who's undertaking another job. They would need to do it in time that is not the time they're expected to be in their primary place of employment.
Thank you. So in cases where staff are also councillors, say such as in Bayside, where the Mayor, Ed McDougall, is also the Minister Campus Chief of Staff, what safeguards are in place to ensure there is no overlap between, say, their state government employment and their council responsibilities?
Good question.
Well, you would need to ask Minister Camper that, but I mean, I know I know Ed McDougall, a nicer young man and a more prim and proper man I don't think I've ever met. So I don't think you'd have to worry about him not being able to manage any conflict. I mean, Ms McDonald, I just want to say this to you without taking up any of your time, and that is that all these rules I'm trying to come up with for councillors for conflicts of interest and stuff is not to be gotcha for innocent people. It's to weed out the crooks, and every time for political purposes, and this is not a reflection on you, and I'm not talking about you. Every time for political purposes, you play a gotcha for someone on a conflict of interest, is somebody that would really add value to local government who says, I'm not going to do this because it's too hard. Yeah. You know, it's hard enough being a councillor as it is without, these sort of gotcha rules being used to effectively chase them away.
Thank you, Mitt. Do you think, well, sometimes, like say, if there's a senior staffer who holds a senior role in council, they could be earning more than ministers. What would you say about that? Is that double dipping?
I don't know. So a senior person in the council could be earning more than a minister.
No, sorry. If they're in their not as a council mayor or councillor, but if they're on a ministerial staff and mayor, those combined incomes.
Look, I mean, I fought against this, would you believe, as far back as the 93 Act. Councillors and mayors got allowances, and they changed the word to fees. Now, they don't need to catch themselves having to pay tax on it, but it created this expectation that it was some sort of salary, and then they say they don't get paid enough for what they do. Councillors it's civic service. It's a really important, effectively not much better than a volunteer you do for your community. Whatever they pay you costs you that out of pocket, you know, you're a councillor, you go to work all day, you then go to a variety of functions, you put your hand in your pocket for raffle tickets, pay for entries, pay for donations, pay for the cost of you going to various places. It's not a salary, and it's not like the Lord Mayor of Sydney or something of that nature. So I just think we need to get into perspective what these fabulous councillors, there's 1,296 or 97 in New South Wales, all who are involved in civic service. They need to be regarded, they need to be valued, and they need to be respected, and the crooks and the shonks need to be weeded out.
I totally agree. I might turn to the Office of Local Government. You mentioned that, you know, they've 45 gone up to 120 staff. What new functions are they have been undertaken as a result of this? It's almost 3 times the employment, 3 times.
Yeah, Mr Whitworth, all this staff that you're getting from the Office of Local Government now, from the 45 you had on the 30th of June, that
has it led to an increase in productivity?
Mrs McDonald wants to know what they're actually doing.
Well, we have undertaken a number of major and fairly deep reforms where we talk about, I'm happy to talk about this and take up some time. You know, this is a really good story for the Office of Local Government. We've been able to participate in and provide a government response on financial sustainability. We have the expert advisory panel that has been announced, and we're well and truly off running on that. We've been undertaking work on councillor conduct framework to improve the councillor conduct framework, the release of the meeting code, the release of the free speech guidelines, the introduction into Parliament of a public interest process to deal more directly with, you know, very serious and poor misconduct by councillors. We have increased our capacity and capability to undertake investigations, so we're now able to undertake multiple investigations at the same time. We've continued to deal with an increasing number of pieces of correspondence. We've been able to prepare pretty deep and thorough reforms to companion animal policies, which we're still negotiating our way through government. We've increased the number of grants that we've been able to manage, and we have also continued to provide both outreach services through our engagement program with councils, as well as undertake significant policy reforms, such as the introduction of the mutual recognition policies, which enables food vans, for example, to provide an ongoing, service to nighttime economy. So I'm actually really proud.
I might come back to this in the afternoon with you, if you like. Minister, what has the cost of this increase in staffing been to the taxpayer?
The Treasury allocated 37.2 million.
37.2 million. And Minister, the expert advisory panel on local government that you just referred to there, Mr Whitworth,
yep.
Has it been formally established?
But it has been formally established. Have we announced who it is yet?
We have announced yesterday. The day before. We put out a newsletter to advise the membership of the panel, and we're now organising the time frame. So it's in the Office of Local Government newsletter.
Okay. So we don't know who's appointed yet.
Yeah, we can tell you who's appointed.
Would you like me to do that, Minister?
Yes, please.
We have appointed Councillor and Mayor Phyllis Miller, OAM, who's the Mayor of Forbes Council and former Local Government New South Wales President. Mr Ray Brownlee, PSM, who's the General Manager of Randwick City Council and has experience in other councils such as Northern Beaches and Auburn City Council. Mr Kerry Robinson, OAM, General Manager, Blacktown City Council. Mr Mark Ferguson, who is the General Manager of Eurobodalla Shire Council and has previous experience in a number of councils. Ms Melissa Boxall, who's the General Manager of Temora Shire Council. Mr Daniel Paps, who is the Manager of Industrial Rules, Governance and Compliance at the United Services Union, and I will be its Chair.
you'll be the chair.
Yes.
Congratulations.
Thank you.
Um,
Yet another thing I've involved myself in.
and my colleague, the Honourable Nicole Overall, was talking about financial reporting and being a, I think in rural areas, financial reporting can be a burden. Why has the progress on reducing the reporting burden been slow?
Reducing the reporting burden. I don't know what that means. Maybe you can work. Do you know what that means?
Well,
I
think
suspect
like the Auditor General noted slow progress in decluttering financial reporting, and that from that New South Wales Council's
the 2025 local government audit reporting to councils by the Auditor General. Yes, that's quite a specific reference to special purpose financial statements and the Auditor General's desire to have those either not mandated or shifted into a different form. Those special purpose financial statements are typically there for the water businesses of councils, so the sewerage and the water business. There is a difference of opinion across the government sector as to the role and function and importance of those, and we have a code, an accounting code working group that has been looking at that and seeking to try and address that. So what you're actually seeing is, you know, and I say this with respect to the Auditor General, is their independent view that we're not moving quick enough, but they have been part of the discussions and they appreciate the reasons why my colleagues in the Department of Climate Change, Energy, Environment and Water are somewhat reluctant to see those special purpose financial statements removed.
Thank you. Minister, with the special rate variation, would you accept that the SRV request process may be drifting from its original purpose?
Yes.
Yep. And
that's why we proposed to change it in the as part of the government response to the financial sustainability inquiry.
And what's the progress been on that?
Well, the government response has not been all that long in the making, and we're going to utilise that expert panel that's only just been appointed. It has a number of other tasks. I've talked to you before about changing the council's financial systems and so that the ability of council's financial systems are far more transparent to the public, to councillors. It was I didn't have much support initially, but I've now got the support of the other ministers for local government in Australia. The Treasurer has written to the Australian Accounting Board unsuccessfully about saying that the accounting standards applying for local government in Australia are not fit for purpose, and they clearly aren't, because they don't tell you much at all. But I've got the Auditor General on board. He agrees with me, which is unusual for an Auditor General to agree with a minister, but he agrees with me. It's going to be one of the tasks for the expert panel.
I'll just divert quickly to federal financial assistance grants, because you said you're advocating. What advocacy has New South Wales undertaken to increase those grants?
Constantly, and they've had a House of Representatives committee inquiry. The federal minister is on board. I mean, we really would like to get it up to 1%. I mean, I won't be too popular with metropolitan councils, but you know, the New South Wales Grants Commission is, in accordance with the national principles, doing everything to support the smaller rural and regional councils in this state. And I just make this observation as well, because we've got plenty of time, and that is that, as you can appreciate, as I visit these rural and regional councils, there's not a vote in it for the Labor Party. It's not done for any political reasons other than, firstly, a learning exercise of me as to what pressure they're under, and secondly, to support them, because they do such a remarkable job in regional New South Wales. They are the most impressive people.
I agree.
Do you know, last year I went to Wentworth to open their Community Information Centre council chambers, and they built for $17 million, I think it was, on budget, on time, with local architects. I mean, it's just quite incredible what these small places in the middle of nowhere are just able to do, and they're actually, it's a pity they're so remote, because they're actually leading examples of what the actual local government sector is all about.
Thank you, Minister.
Thank you. Dr. Amanda Conn.
Thanks, Chair. Just continuing this line of questioning around financial pressure on rural and regional councils, I wanted to ask you about the cost of elections. So specifically, a recent example's been brought to my attention. Uralla Council is required to have a by-election. Now, back in 2024, the cost to that council for the whole election for 9 councillors across 2 wards and a constitutional referendum cost them $76,000. They are now being charged $140,000 for a by-election for 1 seat. That's actually 10% of the value of their SRV, which gives you a picture of how small the total budget is for a council this small. What are you doing to rein in election costs for councils?
Well, without being cheeky, democracy is not cheap. There are cheaper ways to proceed than having the democracy. And as a matter of theory, each level of government, whether it be federal, state or local government, have usually involved paying for its own elections as a matter of principle. In about 1987, I think it was probably at my urging, the running of elections was handed over to the Electoral Commission, and historically the Electoral Commission was charging councils more and more and more, being the cost of the elections. About 4 or 5 years ago, the former government got IPART to have a look, and IPART recommended that the Electoral Commissioner pick up the administrative costs of the election, and so I'm advised now that the government pay about 55% of the election costs by picking up the administrative costs. That's what I'm advised. I myself have been critical of previous electoral commissioners from being inside local government, and even when I got elected to Parliament, because I think councils have been overcharged for election costs. And for a variety of reasons. I mean, why is the Electoral Commissioner paying to access a government-owned school and then charging the council for it? I mean, I just find all this stuff to be unusual, if I could.
So if I can just bring you back to the question,
yeah.
What are you doing about it?
I'll wait to see what happens to that elections bill that is currently before the Legislative Council. The opposition are proposing some amendments that might have a, if that's acceptable, then that might have a quite a dramatic effect, I would have thought, because that way that would create some sort of transparency. The transparency is what I think is the solution, isn't it?
I look forward to the council doing its job and debating good amendments to that bill.
I'm just being quite circumspect about what I say, because I don't want that to go off course.
Yeah, but in this specific example at Uralla, so if they had reasonably anticipated election costs as part of their budget cycle, they're now having to triple that. They've got a by-election costing double what the 2024 election costs, 10% of their SRV. Do you still think in that circumstance the council should have to bear the full cost of that by-election?
No, but there's something wrong somewhere. And I tell you, just a... So what's that, you remember how much that was? 40 grand or something? What is it? I visited a village called Silverton. It has a population of that has to vote for a village committee of 40 people, 37 people voted. The cost of that election to the village of Silverton was $500 per voter. That's what the Electoral Commissioner charged to run an election for 37 people. So I don't need to be convinced. I just cheekily said that, you know, I'll get the returning officer of the Kensington Kingsford branch of the Labor Party to run it for nothing. I think there are really significant problems, and it's very difficult dealing with a external statutory independent organisation to necessarily obtain the transparency, and I don't want to just have, because the council's complained, just sort of pick up the costs. But I mean, that's probably.
While we debate the legislation, would you consider a relief for those councils who are being impacted directly now?
Look, I just if you can get that to me, I just might have a talk to the Special Minister for State about that, because that's just examples of because I don't want councils to, as you know, we've talked about, I don't want them not to have by-elections because of the cost of by-elections. I don't want their motivation of having countbacks to be simply a cost issue. So if that's another extreme example, I'll just.
It is. Look, it was my understanding that the council had also written to you, but I will forward that correspondence directly to make sure that you've got it.
1,600 people write to me, so just because that doesn't necessarily mean I see it. But anyway, I'll just take that up. That's a really good example. I could use Dr. Conn to be able to pursue an agenda that I've actually been pursuing for 20 years, actually.
Can I just come to a different...
Sorry,
Mr. Whitworth.
Sorry, I was just going to say we can try and get some information for you and perhaps talk about it this afternoon.
Excellent. Thank you, Mr. Whitworth. Can I come to a different question of infrastructure contributions? So in particular, do you have any mechanisms for oversight or compliance when infrastructure that's been funded by developer contributions is diverted from the original plan?
Those amounts are restricted funds, aren't they?
They are restricted funds, yes.
So if they apply them, inconsistent with the purpose of recovering them, then that is something that we can do something about.
Okay. Can I please bring to your attention a specific example?
Yes.
Which is the Hills Shire Council's Contribution Plan 2019, so residents of the new Showground precinct. Those developer contributions were intended through the 2019 contribution plan to go to recreational facilities for shared community use. That's now been replaced by a plan for a centre of excellence for a single sporting code, which in my view seems inconsistent.
Is that Eastwood Rugby Union thing, is it? Oh, okay. That's a different... So that's beyond plan of management. That's actually misuse of possibly using restricted funds.
Well, it seems to me that this is quite a different use of funds from the developer contributions that should have gone to benefit community use of that facility by new residents of the precinct, and this is quite a different proposal now.
Okay. All right. Well, we can have a look at that. I know that there was some litigation, isn't there, in the Land Environment Court?
There is. But not in relation to that particular matter. That's the first time I've heard of that, so we'll take that on notice.
And there was an issue in conversation with Ryde Council about the application of funds from one development contributions plan to another, but this is getting into questions that are perhaps better suited to the Minister for Planning, because it's not about the use of restricted funds as you've just presented it. It's about whether you are able to say funds collected for one purpose under a development contributions plan can be moved to another set of similar activities under a revised development contributions plan. And I do know that there are planning guidelines that dictate or set out principles about how that's to happen.
Sure, I
You know,
appreciate there's a...
we will check to ensure that at least the requirements on our part have been adhered to anyway.
Thank you. I appreciate that.
Yep.
Last question for you, Minister. You're aware of the judgment of Darley versus City of Parramatta, and I think you referred to some of the issues at Parramatta earlier this morning.
Yeah, and I made some observations about that last time. I think that I'd read the judgment shortly before coming here.
Yes, and I think there's some important lessons for the whole sector in that judgment. Will you be issuing a circular or similar to councillors to ensure that particularly general managers are aware of that judgment?
I saw a document from Parramatta Council in terms of the mechanism that they were using to try and divert away from the code of meeting practice. What I found quite bizarre was that for their strategic meeting sessions, they made provision for their briefing sessions of councillors to be chaired by the general manager. Well, they call them CEOs. They're not CEOs, they're actually general managers. I don't know, I feel like I should regulate that title out of existence, but in any event. And then provided for all these rules similar as to how they could throw a councillor out of a briefing session. This concept of somehow or other, this fundamental belief that a chief bureaucrat would chair a meeting of councillors, including the mayor, and have some authority over them, demonstrates to me to be a culture in an organisation that seeks to treat the elected people with disrespect. You know, so apart from the fact that the document's bizarre, the mode of reasoning or the fundamental belief that somehow or other the councillors sit below a bureaucrat when they're the elected heads of the council, I just find to be bizarre. So I think there's a cultural problem at that council, which seems to and which just needs to be addressed. There is can I just add one more thing, because we do have time. A particular general manager went to a council, a rather large council, and the first thing he did was he took all the directors and managers down to the foyer of the council chamber, where they had the photo of the 15 councillors up on the wall. And all he did was he pointed to them and said, "See those 15 people? They're our bosses." That was the only conversation that he had. And you know, council have to understand, council staff have to understand that despite the roles and regulations of all the participants, it's the elected representatives who are in charge of council areas. And Parramatta seems to have a culture that has got away from what local government should be all about.
Thanks, Minister. I'm out of time.
Thank you. I'm just going to return briefly to the cat containment concerns. One thing I have heard a lot is from the vets that are obviously tasked with having to kill the healthy cats that are then taken in off the street, and they talked about the mental health toll that this takes on them. Vets have one of the highest suicide rates of any profession, and they said that situations like this are actually a huge part of the situation where their mental health is damaged. Will you be consulting with veterinary groups and with the Minister for Mental Health before introducing any laws that put vets in this really awful predicament?
Well, I thought dentists had the highest suicide rates, so...
I think it's vets now. I think it might be vets.
I always thought that was because that's the one place everybody hated to go.
I think it's all about access to medication.
But I'd not heard that before, because don't vets traditionally have to perform that role for aged and dominant pets?
So the way it was explained to me by some vets that representing the industry They talked about euthanasia to an animal that is suffering does not damage somebody's mental health because that's an act of compassion to that animal. But when you're talking about healthy cats, healthy kittens, taken off the street and having to be euthanised, and we're talking about potentially 10 or 100 or 200 in one day, in one go, that is what is mentally taxing on these vets, and that's what they say is causing the most mental health distress for people within this industry.
I didn't know that. I'll seek to access that.
I'm happy to send you some more information on that. My question was really, are you going to consult with vets, and are you going to consult with the Minister for Mental Health in this area?
I mean, was that evidence given to the committee that you shared?
Yes, it was. Yes.
All right. Then I'll make sure I take it on board. I mean, Ms Hurst, even if you put cat containment aside, as soon as new legislation empowers councils with the same role and function as it currently has with dogs, and they start collecting cats off the street, and they start collecting what's called community cats, I mean, but that's going to feed into overwhelming pounds, and it's going to feed into.
And I agree with you.
It's going to feed into more euthanasia rates.
Absolutely.
But there's no mode of reasoning that stops the Parliament from doing that. There's no reason why you would treat cats differently from dogs, would you, in terms of being around the street? In a public area? I mean, look, our inquiry only looked into cat containment, which is very much linked to this issue. And what we heard was that obviously it's much more difficult to contain a cat than a dog, because a dog can be generally, in most cases, in a backyard, whereas a cat would really need to be contained inside. And what we heard specifically for cats is that it is different and it is problematic because, our rental laws, for example, allow a landlord to actually require that the animal is kept outside. Now, a dog can potentially be kept outside in the yard, but a cat can very easily climb a tree or get over a fence. And so we've got a real problem with our rental laws if suddenly the councils are empowered to actually go out and collect cats, and somebody's in a rental property and their landlord says they'll get thrown out of their rental property if the cat's not inside the house. And so our laws potentially are going to conflict in this space. And so, obviously, again, this was all stuff that came up in the inquiry and stuff that I'd like to sort of talk in detail more with you potentially later outside of this. And this is where, my questions around, when we talk about the impact on people trying to leave domestic violence and trying to get into the rental market, 70% of people delay leaving violence because they can't take their animals because they can't enter the rental market. And then, of course, the rental laws aren't companion animal friendly, so landlords can insist a cat stays outside. And then if we've got these council laws, then they're going to conflict with that and make life more difficult for people trying to leave violent situations. And so there's real layers here, and this is why the RSPCA and the AVA have come out against these laws. And I guess they're my questions to you as the Minister, to make sure that you're considering all these complexities as these laws are being proposed to you. Well, I'm certainly considering them. That's why I'm struggling with the decision-making, process. Because, I mean, you've heard the other environmental, arguments, which is also scientifically based as well too.
Well, I mean, that was the interesting thing, is that there wasn't any evidence that cat containment would reduce the impact on wildlife. They haven't found that in other states and other councils where they've introduced these laws, because they can't be enforced because there's not the funding and resources to do it. And so the only impact that we've actually seen, the only evidence we've got, is that the programs run by the RSPCA that are based on working with communities that are more likely to have cats outside, and actually working with residents and helping them to build a catio, or encouraging them and working with them to change a rental agreement, for example, that they were able to overcome these difficulties, and they did see a significant reduction in cats that are actually outside wandering in those areas. And that work was far more effective than these sort of punitive laws that actually punish people. But we'll continue our conversation in regards to that. I've got another question in regards to the Companion Animals Act. When can we expect to see a consultation draft? Is that something you're still planning to put up this year?
I think that's coming relatively shortly. I think that's going to be coming to me relatively shortly.
Okay, and when are you sort of planning any second quarter, third quarter in regards to actually bringing the legislation on?
I haven't seen it yet, so it's got to come to me. I've got to be. I've then got to take it to cabinet, and that requires me coming to a decision before I take it to cabinet. And I'm not looking forward to making the decision because of the competing considerations, and I'm really troubled by not just cats, but we've got 2.25 million registered dogs. 70% of families have got pets. When you read these inquests in respect of dog attacks, what is there, some 1,200 of those a year, and when you look to see which is, I've actually spent the last couple of years looking at this, even though I've never had a dog, but what's involved in training a dog.
Minister, I might move on just because, I'm happy to talk to you about dog attacks maybe sort of offline, but it's not sort of really within my line of questioning today. And I did want to ask you, are you aware that to rehome a dog or a cat, many rescue groups actually have to submit physical paperwork to transfer the animal within council?
You can't do it from the pet registry?
No, you can't.
Yeah. I think the stage of the pet registry is in stage of development.
I understand that too, and
the software is actually named Amanda. Would you believe? I thought,
but Minister, we're still in this very outdated system. I mean, some of these rescue groups are having to actually hand in this paperwork in person, going to council, and there's again a legal problem because sometimes councils are inundated. They may not process that paperwork for several months. And then that animal is still waiting to be legally rehomed to that animal with that new owner because of this delay in the paperwork. Is this something that you'll prioritise in regards to the pet registry?
Well, the pet registry, which was which has been sort of done by Service New South Wales, which is supposed to be one of these terrific turnkey solutions, has cost over 20 million so far, and I'm going to be going to the ERC for more money to complete the project. So that's what the status is. So I can't give you any guarantees at this stage because I'm going to have to run that gauntlet, and I hope I might be better received than when I went last year with when I raised it informally.
But would you make it a priority of yours to ensure that the pet registry is updated for these rescue organisations, knowing what they're dealing with?
The OLG and the department would love me to take it as a priority, and on their behalf I'll be taking it to the ERC, and will be, I'm just in the, it becomes a matter for them in terms of the government's priorities. But I would like to get this thing finished.
Thank you. We've now got 30 seconds for the opposition.
30 seconds.
And then we'll have 30 seconds for Dr.
Righto, quick 30 seconds there, Minister. This image that I tabled yesterday with the Minister for Lands and Property is an asbestos-filled hill at Walgett, and I'll table that for you to take a look at more closely as well. Now, the Minister has promised to meet with, so it's on Crown Reserve land, but it's the Walgett Council who has been attempting to deal with it for 3 years now. The Minister committed to meeting, and as did Ms Fishburn, to meeting with Council to expedite this and ensure that it is addressed immediately. It's within cooey of homes and kids play on it, etc. So I'm just asking that you will also undertake to assist however you can to have it promptly addressed.
I will help. I will help log it whichever way I can. I got so much time for those councils out Western New South Wales, so they do a tremendous job. So,
and I have many more questions. You sure you don't want to stay for the afternoon? But I'll put it out there.
Thank you. Dr. Amanda Conn.
Thanks, Chair. Just briefly to follow up my previous question about the Supreme Court judgment, Diley vs Parramatta. You made some very strong comments specifically about Parramatta. My suggestion to you is that the judgment is relevant to the whole sector and not just Parramatta. And, for example, even simple things like in consideration of a code of conduct report to council, councillors should be able to debate and discuss the whole report, not just the recommendations of the conduct reviewer. What will you do to promote better practice across the state and not just at Parramatta?
I'm really uncomfortable with these private censures and also that sort of stuff. All that's going to change because what's the point of censuring somebody behind closed doors if somebody, say, for example, has done the wrong thing? I mean, the whole purpose of the censure is actually to have a public criticism of the person. And I suppose their mode of reasoning is that nothing's proved. And the other thing is these code of conduct examiners that consistently aren't doing the best anyway. I've seen, I don't see them all, but the ones I've seen, for example, I think I've said to you before, I saw that ridiculous one in relation to the Greens councillor on Bayside. I've seen ridiculous ones in relation to Blacktown and Georges River. I've seen one whereby they were just wrong and the council censured somebody wrongly. And I think I had to get Mr. Whitworth, to get him to try and unpick the censure. So the system doesn't work. So hopefully you'll see in the white paper that will come out soon that there'll be all that convoluted process will be replaced.
Thank you.
Thank you. And we now got a government time. Are there any questions?
We have no questions of the Minister at this time. I'd like to thank him and the assistance provided for the morning proceedings.
Thank you.
Fantastic. Well, thank you. So the committee is finished with questions to the Minister. So thank you again for attending this morning. We will break now for lunch and we will return at 2 p.m.
2 p.m.
sorry, Eileen.
Oh,
Thank you. Welcome back to afternoon session of budget estimates. I'll throw straight away to the opposition, the Honourable Aileen McDonald.
thank you.
I was going to say there were a number of things that we can clear up. Would you like us to
Could
do
we
that? Or?
Do that sort of maybe... I'll do that in between the sessions if that's all right. Maybe just before the afternoon tea break or something like that.
Sure.
And then-
Thank you.
Thank you.
All right. Do I address to you, Mr. Whitworth, or?
It'll generally be to Mr Whitworth unless
Okay.
it's a broader departmental
Yep.
or corporate matter
Okay.
or
All
crossover with the different parts of my department.
So I understand the Office of Local Government is in Nowra, but you also have offices in Sydney. What is the split between Nowra and Sydney, where you've got your 120 staff?
Well, it's an FTE of 120, which includes
okay.
board members as well. So the number of staff is slightly less. We utilise the Department of Planning, Housing and Infrastructure offices. So I have staff, and we have a flexible workplace policy. So I utilise and our staff utilise the offices of the department across the state. Predominantly, we are about 50% of our staff are in Nowra. I'm happy to give you the detailed numbers on notice, with the remainder typically in Parramatta, but we also utilise offices in the city, the Parkline offices in the city, and we have people in offices. So we have some people in offices in Newcastle, for example. Did have an officer in Albury, but she's moved to another part of the organisation.
All the departmental employees, not just Office of Local Government, can work in any of the Department of Planning, Housing and Infrastructure buildings across the whole state.
And how many executive roles are based in Nowra then? Or I suppose they're all based in Nowra, but where they choose to work is a different thing.
Well, that's not quite the way in which it works. So you are assigned an office based on your policy, based on when you come into the organisation, what the needs of the organisation are. As I said, we have a flexible work policy in terms of where we're located. So there are some senior executive band members of my staff that have their offices located in Nowra. There are others that have their offices located in Parramatta. My point is located in Parramatta as an example, but that's about how I was allocated the job and those circumstances. But I cannot stress enough how we do work flexibly. We use audio-visual technology regularly to meet. We travel to make sure that we can meet in person as much as possible. I go to Nowra as much as I possibly can.
We're going next Wednesday.
We are going next Wednesday. I have struggled when Parliament is sitting. I'm almost tied to the city, as you would expect. But we do try and interact with our staff as much as possible.
And when you're, say, like you're going to Nowra next week, and you've got the other, are there inefficiencies identified arising from having a split location, or how do you address, being able, like you said, audio-visual, and you do travel, but has anyone identified any inefficiencies as a result of having a split location?
I don't believe so, and that's just about being a good manager, is knowing how to work with your people. And I think the days are gone where managers can only manage people if they can see them. You, as a leader, your job is to set a clear vision, encourage and ensure that your staff are part of that vision and give them the tools, the resources and the direction to get on with it.
Yep.
Can I add something further to that? I actually would argue, on the contrary, that one of the strengths of the Department of Planning, Housing and Infrastructure is that we do have offices throughout the state. And the reason I see that as a strength is it means we can employ people who might not necessarily choose to live in Sydney, but also we can better understand the needs of rural communities and communities that aren't just metropolitan Sydney, so the Illawarra and Newcastle as well. It's one of my greatest pride and pleasure to be able to get out and meet with our staff everywhere from Jindabyne, Queanbeyan, Nowra, Wollongong. We really are geographically spread across the whole of New South Wales, and that's something I certainly would not want to see changed.
And do you think, or has a review ever been conducted into, say, the cost benefit of maintaining different offices in different locations?
Well, inarguably the most expensive office locations are going to be those in Sydney. So while I don't think there has been any analysis undertaken, I can certainly guarantee you that a office seat that is located outside of metropolitan Sydney is less expensive than an office seat, particularly in the Sydney CBD, where we have a very limited footprint because of that reason.
And so probably for that reason, there wouldn't, I presume there aren't any plans to fully locate back in Sydney or fully locate in Nowra?
Certainly, there's been no direction from any part of government to me to do that, and my preference as the departmental secretary would be to retain the type of footprints we have across the whole of the state.
And so that would be the advice you would provide if asked?
If asked, yes. Yep.
And you haven't been given advice or received, or you said that before, you haven't had any directions?
No direction.
And I might add that we have been investing in our Nowra facility and our office to make it a much more contemporary space and a safer space and a better workplace, which has led to us being able to move from having 2 floors to having 1 floor.
Okay, that's good. And so how does your department define the core role of the Office of Local Government?
The core role, so I think the core role of the Office of Local Government is to act as a regulator for the local government sector. We have a strategic plan and we've identified what we do as part of the corporate plan. Both the corporate plan and the annual report of the department in terms of the roles and functions that we operate under.
Okay.
Is there a more specific?
I was just wondering, I understand that the regulator, the type of thing, but are you also a support body for councils as well?
So I believe the way that we approach regulation is to create the framework within which local government needs to operate. We work with councils to build their capacity and their capability to operate within that framework, whilst also taking feedback from them about how well that framework is suited to the circumstances, and so we can continually change and evolve, and then we intervene as often as is necessary, but as little as is possible, where there is a divergence out of the framework. So there are different approaches to regulation. What we're doing is regulating to say we're not overseeing every single decision of councils, and that's not an appropriate approach to take, because councils are elected, they're run by elected officials to represent the views, aspirations of their community. The councils themselves under the Local Government Act are established as independent authorities. They should be able to have that discretion to spend money as is appropriate based on their planning and their consistency and with the Local Government Act. What we do ask is that they provide appropriate reporting and that they utilise the guidance that we give, which helps to set that consistent approach to how the sector operates.
And so in practice, are you seeing that you're fulfilling that role as being, being able to be a support, but using the regulatory framework that you have?
We were discussing this just the other day in terms of how do you measure measure the absence of needing to intervene as a performance measure. The success of our outreach. I have a team called the Council Engagement Team, so Council Engagement Managers. I move them as part of our restructure from the policy area into the Office of Deputy Secretary so that they could be at the heart of the Office of Local Government and effectively represent me in engaging with General Managers. So they do that on a daily basis to understand the issues and concerns of General Managers. I have spent a lot of time working with General Managers to understand their issues and their aspirations or the matters that they feel I should be looking at. I think that if you asked a General Manager, hopefully they would tell you that I am available and open to them and regularly engage with them.
Mr Whitworth's quite modest there. I speak to General Managers obviously as often as Brett does, and that feedback that Brett is available and open, as are his executives, and in fact that the Office of Local Government provides great support and guidance I get that every conversation I have when OLG is brought up.
Mm-hmm. And would you say, has there been improvement in, say, performance measurement and reporting since past audit office concerns?
If you took a raw number of the number of councils that had unqualified accounts, then we've done miraculously well in the last year because we're not talking about the red fleet impacting the qualification of accounts. So this is where it's always dangerous to use a metric like that. I always think that I've talked to you about my regulatory role and to build the framework. What I haven't talked about is the one job from Treasury, that is to make sure that councils don't go broke and that we need to step in. And we have been using a risk-based approach to understand those councils that have quite challenging and fragile financial positions and work with them in quite a lot of, work with them to try and head off any disaster. So I also take that as being that we know that there are a couple, but we're also aware of what they're doing. We work with them hand in glove to make sure that they can recover and that they've got a path to financial sustainability set out.
Yeah, I don't envy you. And on notice, would you be able to provide evidence that OLG is regulating the sector effectively?
I don't know how I could provide that on notice respectfully. That's what sort of metrics do you want me to use? Like it's like are you well regulated? Sector says yes.
Yes, okay. Difficult question, okay. Well, then do you have clearly defined priorities and enforcement thresholds then?
Sorry,
you sometimes have to be the carrot and the stick. So do you have sorry. Like if I was a general manager to ring you, would you be able to say to me what the priorities of OLG are, and if they're not sort of complying, what the thresholds are?
So my priorities for a general manager, my priorities in terms of what I'm doing, I want to ensure that I have a stable local government sector that can provide local services first and foremost to communities. So communities need to be able to work with their council. They need to have confidence in their elected councillors that local services are being provided. I also have some other priorities in that I want to establish greater financial sustainability and stability for local government. I want to ensure that the councillors are able to effectively and transparently run their councils without there being an overarching political conversation about constant code of conduct complaints and so on. I also want to ensure that we have councils that are able to help address some of the significant challenges that we face in New South Wales. We have a significant challenge around the delivery of more housing, which isn't just increasing number of housing, but it's also about the diversity of housing and increasing the amount of social and affordable housing. I want to ensure that councils are part and parcel of the process to adapt to a changing climate so that our communities can become more resilient in the face of increasing disasters. I want to make sure that our councils can help engage in the move to net zero and the increasing use of renewable energies and the number of renewable energy zones that we have to make sure that those renewable energy zones do what they need to do and provide, sustainable power for New South Wales, but also that the local communities can take advantage of that sustainable power being delivered through wind, solar, battery in their areas. And I also want to make sure that as we see more services being provided in the digital environment, that cyber security issues are addressed. So those are like the high level issues for me. And I hope you see that, I should also say that we are addressing the way in which companion animals are regulated and managed. So if you look at the reform priorities that the Office of Local Government is pursuing and advising this government on, we have financial sustainability, we have councillor conduct framework, we have companion animals, and I'm also participating in and driving certain changes around housing affordability, including representing New South Wales in national forum around housing and local government interaction. I sit on the Disaster Recovery Fund Agreement Board, chaired by Reconstruction Authority, and we are also engaging with Digital New South Wales and Cybersecurity New South Wales on the issue of cyber. Plus I am part of, we've rejigged the governance, but there is a group of deputy secretaries who are now advising the secretaries on the delivery of the roadmap for electricity infrastructure.
Because it's a big reform agenda and list of priorities. Do you think that the local government sector is understanding of those priorities and the reform that's needed? And are they, I suppose, they can't always work with you, but are they trying to work with you on that, or how are you working with them?
I think that is there will always be tension. I don't want to be a regulator that hides away and then pops up and says, oh, you've exceeded a particular measure and you're now in trouble. I want to be a regulator, as I said, that works to create a framework that they can operate in, and then that we are recognising that these are joint challenges that we have that we need to address. And if you look at some of the products that we've released, the affordable housing guideline, for example, about councils being able to use surplus operational land to deliver affordable housing, that's been quite well received by a number of councils, not just in metropolitan areas. And so these are practical examples where councils, general managers can work with us to help deliver those broader outcomes.
And they're all positive. What about when we have to look at enforcement? If a council isn't complying, how are you on I won't say prosecuting, but going down that enforcement line?
So look, I don't want to be the only person that talks here, but Ms Hickey is responsible for the sector performance area of the office, and perhaps she can talk about some of the approaches we have for intervention.
Yes,
Thank you.
Thanks, Brett. So we obviously have the investigations side of things and the interventions team, and so they will look at things, complaints that come in, triage those, investigate or ask council to report back on how their investigations are going. But we do our own investigations, and sometimes that leads to we often do preliminary inquiries under 734A of the Act, or we might do misconduct investigations, or we might go down the PIO route or public inquiry. And then on the other side, the financial performance side, we do risk assessments of councils and how financially they're going, and we'll monitor that. The team works with the councils pretty intensely once they've flagged which ones that they want to work with, and they will assist them to make sure that they're on the right track with long-term financial sustainability plans, and flag any issues in terms of internal loans or anything like that with them. So.
And the team, does it have a name?
So the financial, that is delivery and performance team.
Delivery and performance team. And how many people are in that team?
There's 20 people in that team, but that also does things like the Grants Commission Secretariat and the review of the statutory applications that we get from councils for compulsory acquisition. And I'm going to forget other things in that team. Boundaries Commission.
It's a lot.
Yeah, it does the demergers, for example, as well. So
quite a lot of.
Yeah.
My time is up.
Sorry, and it does the programs. It does all the grants programs.
That's a lot, 20 people.
Sorry about that, Steve. I'll just say that.
Dr. Amanda Cobb?
Thanks. I had some questions about companion animals related matters. The first one was just to follow up a question from the chair this morning about the Companion Animals Act review. I think the question was about the draft white paper, but I understand there was previously a commitment to publish the submissions themselves. Is that still on track?
We have published the submissions, I thought. Ms. Rama can answer.
Yeah, there's a briefing package that it's working its way through government.
Oh, sorry. Okay. Sorry. Let me rephrase that. We have prepared I think the Minister alluded to what we have prepared. That's something that he's considering. So we have a policy approach, call it a white paper, and we were going to release the submissions at the same time.
Okay. And is there an expected time frame on that?
I can't give you an expected time frame on that, other than to say that we are. I think if you considered the Minister's testimony from this morning, you can see that he's clearly been engaged by us in terms of the issues, and he is considering them. So we have clearly put a number of different options and proposals to him.
Thanks. The pound data, I understand that councils report that to you by the end of a financial year, and then there's a delay in that sort of processing time, but it appears that data's getting later and later. It wasn't published until January this year. What are the barriers to being able to publish that data in a more timely manner?
Ms. Brahman?
Yep. So in June of, last financial year, we had some people moving on who managed our companion animal registry, which means that we've had to retrain some new people to access that material, and that's happened. And then it's a matter of just processing and then refining it. And yeah, as we have turnover new staff, we have to read that up.
Can I also say that it is a proposition was put to me that we should seek that data more frequently as well, because we're getting it once a year. There's a lot of reviewing that data. You're getting 128 different versions of a form or a spreadsheet. There are a lot of inconsistencies, and it's about working through those. Plus, these are the people that are also dealing with the pet helpline and taking calls and emails on the pet helpline around registrations. So ideally, as part of the companion animal review, which will also give us the opportunity to review the companion animals regulation, we can help to address that and maybe getting more frequency of submissions from councils.
Okay, thank you. And notwithstanding those proposed changes as part of the companion animals review, it sounds like if those staffing issues are now resolved, we can anticipate a quicker process this year?
Yeah, I'm very hopeful.
Thank you. Can we get an update on the the breeding code of practice?
I will kick off, and then I'll also hand over to my colleague, Ms. Connell. I think we have identified through the government's response to the Pound inquiry about the importance of that code. It is something that is on the work program of both of our agencies, and that we are engaging with our ministers around what it would entail and the work to produce it. Ms. Connell, have you got anything else to, or Mr. Day?
Yeah, thanks. Yeah, so look, we are committed to doing that work. We've developed a consultation plan for the breeding code review. We held an initial targeted information session last year on the 15th of December, and we are now conducting further targeted consultation with stakeholders, including AWAC, on the proposed amendments to the code, with stakeholder feedback planned for submission by about early April. We've also been pretty busy delivering our targeted public awareness program around the puppy farming, which then also connects with that work as well. You know, a lot of social media interest and hits on that so far. So we probably are running a little bit behind schedule with that, unfortunately, because of workloads and other competing pressures, but we are committed to it, and as we just said, we are going out now for targeted consultation.
Thank you. I certainly don't want to be misinterpreted as criticising consultation. That's obviously a really important process. We were previously advised that the code would be finalised by the 1st of March, so it's obviously passed. What's the new expectation in terms of the timeframe?
We're probably looking at the mid this year.
Okay. Also, following on from a line of questioning from the Chair earlier this morning about rehoming organisations and the like, a really common concern that I hear are the issues with lack of temporary or crisis pet care, and I know some pounds run by councils do that on a voluntary basis, but this has particularly been an issue following natural disasters or for people fleeing domestic violence. Is there any specific work underway to improve that capability?
Look, I think that as part of the work that we are doing on the broader review of the Companion Animals Act, what comes forward quite frequently is, as you start looking at some of the policy levers to address dangerous dogs, dog attacks, as you start looking at the levers around increasing cat populations and unowned cat populations, and I'm not making an argument for increased euthanasia there, but simply the fact that as we start looking at other options, there will be a potential for more animals to come into the rehoming process. And so we can't just change legislative provisions or regulatory provisions and say we're going to increase the circumstances within which there might be a possibility that an animal is put into the rehoming system without also looking at the way the pounds operate. But that also means that you've got to make an argument about how effective are those pounds now, how effective do those pounds need to be, how effective is the rehoming network, and should there be a way of supporting that through increased funding. Now, that's going to be a matter for the government and a policy decision for the government.
Okay. There was a inquiry into public toilets by this committee. Was the Office of Local Government involved in the preparation of the government response to that inquiry?
We were.
Okay. In what capacity or what advice?
We were consulted.
There was a consolidated departmental response from the Department of Planning, Housing and Infrastructure.
Yeah, understood. And I appreciate that inquiry crossed a number of portfolios, and this was one of the key issues we tried to address. I'm trying to work out which were the parts of that work which the Office of Local Government fit into.
Well, I mean, the thing about public toilets is if this is an expectation that councils take responsibility for the provision of public toilets, then we will be selling ourselves far short in terms of a state into the availability of public toilets, because publicly accessible toilet can be on private property. You know, there are lots of publicly accessible toilets that are in shopping centres, that are in sporting facilities, that are in registered or clubs, etc. So I know the government's response is that it did not necessarily accept the recommendations of the committee and noted a large number of those. We were, I suppose, wanting to make sure that where there were standards, that they would be appropriate standards that councils could comply with and could accommodate. But at the end of the day, I suppose you have a local council to provide local services. It's up to the council as to the best way in which it can do that, and having a conversation with the community about the availability of public toilets is part of that. It's part of their intrinsic nature of service delivery. I really can't sort of provide a more, a different answer than that.
I might come back to the minute. Thanks, Chair.
Thank you. I'll just ask one follow-up question to Mr. Day in regards to the questions from Dr. Con. You mentioned that there was a consultation on the 5th of December on the breeding codes. Could I get a list of who was part of that targeted consultation? If you don't have it, I'm happy to have it on notice.
I'll take it on notice. It was the 15th of December.
15th of December, thank you. And also, I think you said that there was another round of consultation. Whoever may be part of that as well would be really useful. Thank you. Could I get an update on where we're up to on the work on the pet registry?
Certainly. I'll start and I'll hand over to Ms. Rahman. I think we've previously given evidence as to the completion of the Link My Pet stage and the desire for further stages being the various portals, but we were dependent on government funding for that. We also needed to address the demands that would be put on the pet registry through the puppy farm provisions and legislation. So our most immediate focus has been on the changes to the registry to incorporate puppy farm provisions, which I'll get Ms. Rahman to talk about. We continue to identify how we can improve the functionality of the pet registry, but it's a nature of how you're engaging in digital solutions. I mean, we are talking about a database which has over 4.5 million records of, it's not just records, but it's names and addresses of people that live in New South Wales. So there is always an intense risk around having inappropriate access to that. So that also has to be our first and foremost concern. But I suppose I'd like Ms. Rahman to talk about some of the functional changes that we've recently introduced as part of the puppy farm provisions.
Yeah, sure.
Thank you.
So as part of the puppy farm implementation, which is how we refer to it, on the 1st of December, new breeders were invited to log on, and unless they had an activated bin, they weren't able to do any of their activities as a breeder. So no transferring of their litters or registering a litter, none of that it was available to them. So in order to have access, they had to do two things. Firstly, it was that they had a bin. If they didn't have a bin, that's fine. They could immediately and instantly apply for one and get given one. That's no problem. The other part was acknowledging through a declaration. I like to think of it like a terms of agreement, terms and conditions upgrade on your phone. It's just that the legislation has changed. Under the Puppy Farm Amendment Bill, you've got these additional requirements that talks about the ratios, play, all of those sort of compliance with the breeding code, all of that is there. And you have to acknowledge that you understand and accept those. And then that's, then you're able to use the functionality. So that was the, I guess, the high level overall implementation into the pet registry. So that was done in 2 phases. Phase 1 was the declaration in the bins because you needed that for going live. And then actually last night was the first successful go live of the second stage. We'll have another one at the end of March. So we're phasing those bits out so that we can test and make sure that everything is working smoothly. So far, so good. And in the first stage of release, there were no incidents in hypercare, so that's pretty good.
So can I also just add that in terms of then the broader elements of the pet registry, we have completed a health, because it's an infrastructure project effectively, through Digital Restart, we've been required to use the health check process. So we've gone through what's called a Gate 6 review, which is effectively the finalisation of the expenditure on the first stage of the pet registry. It provides very sobering reading and has given advice that I need to consider and get an independent perspective on what is the best set of technology and digital solutions for the pet registry. I've gone out and sought external independent advice on that, and we're in the process of considering that as well.
Thank you. And I'm really interested, Ms. Rahman, in what you're saying about this sort of agreement, which I think sounds like a really good idea. I think that's a fantastic way to make sure people are across the requirements. I'm wondering if that agreement also included information about the laws that passed fairly recently that certain people cannot breed animals. So if they've been found guilty of certain cruelty offences.
Yeah, it would have included that.
Oh,
I don't have it in front of me.
Could I get a copy of it on
yeah.
notice? If that's okay, yeah, that would be fantastic. Thank you.
And excuse me, Chair, we've just got the information to hand about consultation on the breeding code.
Yes,
Right,
certainly. Yep.
So, Chair, on the 15th of December, we met with a number of reps from Animal Care Australia, Pet Industry Association of Australia, the AVA, Dogs New South Wales and the Australian Association of Pet Dog Breeders. And then the actual broader list of that we'll be doing some further consultation with is Dogs New South Wales, Master Dog Breeders Association, Australian Association of Pet Dog Breeders, Pet Industry Association of Australia, Australian Federation of Livestock Working Dogs, Cat Breeding Associations, Cats New South Wales, Cat Protection Society, Cat Fanciers Association for New South Wales, Australian National Cats Incorporated, and then also the ACOs being RSPCA, Animal Welfare League, Police, GWIC Welfare Greyhounds, and then general interest groups being AWAC, being AVA, Farmers Association, the New South Wales Veterinary Practitioners Board, Animal Care Australia, and we've also, and with a number of other the dog breeders who actually have applied for exemptions as well, we'll meet with those.
Yeah, I mean, there's obviously a very significant number of breeding organisations. Most of them are either breeding organisations or heavily involved in some way with breeding. The only sort of welfare groups I can see is the enforcement agencies. If I kind of put them to a side, the only one I heard you read it was the Cat Protection Society. Will there be other sort of animal welfare organisations or organisations that are concerned with backyard breeding, with puppy farming, and that have been campaigning in that space? Will they be incorporated into some of that feedback at some point?
That's our primary list at the moment, but certainly we can see about meeting with other groups as well.
Okay, yeah, fantastic. I might email and some other groups. That'd be fantastic. Thank you. So in regards to the pet registry, am I right in thinking that the money at this point has been exhausted, even for the puppy farm aspects of that?
Yeah. Yes.
Thank you. And last time we spoke, there was 9 staff working on that upgrade. Are they still there, or have they sort of been integrated into other areas in the companion animal space? I know you said there were staff changeovers, but is there still sort of 9 people potentially available to work in this space, or
working in companion what we're trying to do is transition people to work in the companion animals policy space to support the pet helpline and
the programs work, the system support. So the team that were working on the pet helpline, they were all basically contingent or on contract, and we have been recruiting for those broader other streams, and some of them have been successful and will be rolled into the team. So not all of them will continue on, but some will, but in those new roles.
Thank you. And so there's nobody now working on the upgrades because
They are still. It's still going. It's still ongoing. I would say late March is when the work will finish, but the team will, unless they've gotten another role internally, by April.
Sorry, and I should have said, has the money been exhausted? In terms of the budget allocations to us, they have, but those budget allocations do include the ability to basically employ people this financial year. So that's not, so it's not that we're getting to the 13th of March and then that's it, there's no more, but...
For the future aspects that we all want to see as part of it,
yes.
They don't have the funding anymore. Yeah.
Yes.
Yeah, I understand that. Thank you.
Sorry, Chair, I just realised my answer before, I forgot to mention Cats New South Wales attended the 15th of December meeting as well.
Okay, thank you.
Well, the Cats left out.
And could I get an update on the work of constructing the new Sydney Cats and Dogs Home shelter?
Sydney Dogs and Cats Home is a really fantastic project that is frustratingly close to being finished but not yet finished. So my understanding is that we are all but finished in terms of the construction of the first stage and all but ready to hand over to Sydney Dogs and Cats Home, but we have come up with a sewerage connection or a sewer connection issue. There is quite a history to this, and I could take about 5 or 10 minutes to take you through it if you're so happy for me to do.
I won't frustrate the opposition with that, but...
So, look, the short version is that we are seeking a way to connect to the sewer. The way in which the development approval contemplated has not been made, is not available for various reasons, which means that we need to create quite a large holding tank, which means that we've got to put in sheet piles, which means a dewatering process. The Sydney Dogs and Cats Home facility sits between the largest petroleum storage facility in New South Wales, if not Australia, and Sydney's desalination plant. So it's not an area that you can simply go and drive a couple of big sheets down into. So there are approvals that we need to get. There's also the construction of quite a complex sort of set of tanks that will hold the sewage from the facility and then it gets pumped into the Sydney Water Network. So that's additional cost and time that we're seeking to resolve. We're also talking regularly with Sydney Dogs and Cats Home, and we want to make sure that they can be still operational to move into the fantastic new facility that has been constructed for them.
I can assure you that this is a project of particular sensitivity to myself, as Mr Whitworth will testify if asked, and we really want to see it completed, and we're keeping Sydney Cats and Dogs well and truly updated.
Great, fantastic, thank you. The opposition?
Thanks, Chair. Mr Whitworth, could I please come back to the potential changes to the Code of Conduct? Is the process being improved when it comes to complaints about a general manager or a mayor?
You might need to give me some more context on that, Ms Overall. When you say improved, what's the flaw?
Well, is the current process is that if there is a complaint about a general manager, it goes to the mayor. If there is a complaint about the mayor, it goes to the general manager. Is that correct?
If there is a complaint about... So the general manager, under the existing procedures for the administration of the Model Code,
yes,
the general manager receives all complaints made about a council other than any complaint made about themselves.
Mm-hmm.
So complaints about councillors, council staff, etc.
Yep.
The discussion paper that we released posited a new approach where we talked about separating the council staff code of conduct process and continuing to follow the existing processes for the administration of complaints, and creating new processes for councillors, which would involve a privileges committee, which would therefore mean that complaints about councillors, including mayors, would no longer go to the general manager. They would come to the Office of Local Government for triage to go either to the privileges committee or for investigation by the Office of Local Government if it's a matter of serious misconduct.
Good. And so that's a discussion paper, you've said?
That was a discussion paper that was released in 2024. The Minister talked about the new policy approaches and a potential white paper in his testimony this morning, and that will have the detail of the Privileges Committee and how we're going to make the new process work.
Okay, so we're still waiting, in other words.
Still waiting
but it's definitely been advanced, and obviously then something that the OLG is very supportive of.
Well, we're developing up the like I have. Members of my staff are invested in making this process work now by developing the procedures. We also have the new provision. So the amendments to create the new councillor conduct framework are in stages. So there's already a bill that has been introduced into Parliament, which we call Stage 1, which would enable the transfer of jurisdiction from the New South Wales Civil and Administrative Tribunal, NCAT, to the Land and Environment Court, and to create a public interest test-based faster approach to the Land and Environment Court.
Okay, the faster approach. Okay, that is good to hear, and I will definitely be watching that closely as well, because I'm sure that you know how many difficult situations can arise with that lack of an independent entity or review as such. So I think that's an important step.
Well, I mean, and Dr. Conn started to talk about this in terms of Parramatta versus Darley this morning.
Right. Yes.
The Code of Conduct Examiner process is an effective process if you're dealing with variations from a professional code, but if we're talking about politicians, it's not as effective. You need to have politicians judging politicians, which is hence the Privileges Committee, but with the advice of the Office of Local Government.
Yeah, but not only that, it's also when it's coming to complaints from the public as well, when they feel that they're being stymied, if they're making a complaint about a general manager or a mayor and it's all being done in-house. So
well,
I think this is a good step.
But I respectfully, I'd say that we have independently elected councillors to run their council. Councils are must operate independently as statutory authorities. We are it is quite clear that we have an increasing number of people complaining to us about their council, and we will return those complaints to the complainant and say, this is a matter that you need to raise with your council. It is an independently elected and overseen authority. It must take responsibility for how its staff operate, and the councillors as a group need to...
I'm not arguing with you about any of that, Mr Whitworth. What I'm saying is that if you have, and I do have an example that I'm happy to talk with you about offline, specifically where a member of the public has had a complaint about a general manager and a mayor, and I've seen the complaint and I believe that it does have valid grounds, to then take it to either of those two parties to have it dealt with, to be told there is nothing to see here and now you have no further avenues to have that explored, is not the most effective manner for it to be dealt with. And again, I'm not saying that if it progresses and went to a Privileges Committee or whatever, that it wouldn't come back to say, actually, we have looked at it, there's no grounds to it. What I'm saying is the perception of the independence in how it's being looked at is currently not really there to give that confidence that you want for communities to have in their local councils. So I am very pleased to hear that you are progressing something that is looking to address that. So that's great. coming to that, and the point that you made about community confidence in local councils and councillors effectively and transparently running their councils, which I also agree with. Again, I'm just trying to gain an understanding from a distance on council processes. And again, like, this is, valid questions about I'm trying to find this information. It's not a gotcha moment. Or when local councils have to deal with government departments on major projects, is the process such that the intent is resolved by council and then that's communicated to, negotiated with the government department directly? In this instance, Transport for New South Wales. Is that how it works?
Well, it depends on what's being. Are we talking about a particular standard
a major
road
road project?
So is it being funded by Transport? Is it being funded by the council? Is Transport?
It's some of both. So it's a joint project that it's some government money, some council money as well. So it's the main street in Queanbeyan that is having a major uplift.
So it's a classified road, which means
Correct.
that any
It is a
work that is
classified
done
road,
in
yes.
that corridor would require
Yes.
the Transport's effective concurrence.
That's right.
Yeah,
so I'm just qualifying. So that the council has the intent of the project that they wish to do. That would then be progressed to the department for that consultation, the contract, the agreement to be entered into for the project to go forward.
But typically, again, in everything, context is important. Is Transport operating as a regulatory authority or an assessment authority in issuing an approval? Or are they operating as a funding authority where money is coming through, in which case there is a deed to be negotiated? Typically, you'll find that these things will need to happen under a form of delegation to the general manager and the staff, or if and a general manager that comes across an issue where they feel that they need to get guidance and or direction or policy or authority from their council to act, will put will put a report to their councillors and a resolution to seek guidance and direction.
Okay, and so on that, the delegation, the authority to act, is there a threshold? Is there criteria around that? So if there was a major change to the project, the normal situation would be that it would, best practice would be that it would be that authority that would go back to the councillors. I'm just trying to work out the steps.
It will depend on the level of delegation that the council is prepared to give to their general manager.
So they'd have to authorise that first.
Yes, and typically what we, in terms of post-election guides that we give to councils, one of the things that we always say is to sort out the general manager's delegation as part of the first, within the first couple of months of the council. That delegations are a critical part of the operating environment of local government, be they financial delegations, human resources or planning or other environmental approvals. So it would be, and there are different levels of delegations to different general managers. Some general managers have a much higher financial delegation, other general managers will have
so generally it is based on the financial aspect?
No, I mean, a council to act requires either a resolution that says this is what you need to, this is what we're going to do, or a delegation to an authorised officer to act on their behalf in those circumstances.
And sometimes it'll be whether it's financial alterations but that would normally be specified.
Yeah, they will always be specified. Okay. The instruments of delegation will always be quite clear as to what human resources, financial, or where a council is exercising statutory authority under a piece of legislation, be it Protection of the Environment Operations Act or the Environmental Planning Assessment Act or the Local Government Act.
Okay, thank you. So I do appreciate that. That information's quite helpful. Can I please turn to A couple of other things. The Minister mentioned this morning, and didn't have the chance to get back to him about it because we all had so many great questions, local government workforce and regional council staffing arrangements. Are we seeing, and I'll get to I know the Fresh Start program and how well that's doing, but are we seeing a movement away from councils, and particularly regional councils, when it comes to those professional qualified staff?
I will give Ms Hickey a bit of a heads up that I'm about to throw to her on Fresh Start, because that is
She's
part
got a lot
of
of things that she's looking after.
It's more than just the apprentices, trainees and cadets, but it's the workforce capability that we want to build.
That's right.
We have very clearly framed this program on the basis that there should be as much insourcing of services as possible. And so where there is a preference between a service being delivered by staff within a council or by consultants or a third party contractor, if it's waste services, for example, then the preference of the government has been for it to be an insourced service. That said, there is quite clearly a challenge in having available professional staff, and it's an important part of growing, I think, some of that staff as well. So, Ms Hickey, can I throw to you in terms of how we have the Fresh Start program trying to build that workforce capability?
Yeah, sure. And just also to acknowledge that of the recruits, 61% are regional and rural. So
I was very pleased to read that.
Yeah,
Yes, very pleased indeed.
So yes, it's not just the grants program. There's a workforce strategy attached to the Fresh Start program, and a lot of that is about upskilling within council. And so what the team has been working pretty hard on is delivering supervisor workshops, for example. So I think we're on track to deliver 39 of them by the end of June, and that's a really important part of our retention strategy for the recruits as well. We've also got a couple of pilot programs going about upskilling, and one of them is an AI skills assessment for all councils, and so hopefully we'll have the results of that soon to see if that can be rolled out at scale. That'll be a next year thing. We also have upskilling pilots for example, EV upskilling, so mechanics in councils, how do they know how to do the work on EV cars and fleets. And in fact, that's a really rare skill, so it's really good. Councils are going to be one of the first that can do that. Also civil construction, which is so important to meet our housing priorities, and a lot of water supervisors as well. So those programs are going pretty well, but it's early days yet. So we're really interested to see how they go. Yeah.
So, and that's, it's all great to hear, and I did read as well that the Fresh Start program has approved over 1,000
yes,
apprentices and
1,090,
trainees, which was great. But we are, and particularly in regional rural areas, still suffering shortages in engineers and planners and building surveyors, etc. So
yes. So this is part of the solution. I mean, there's other things that need to happen, I guess, across government, but yes, that's one.
So how many of those Fresh Start positions, and I know that the 61% that you said in regional and rural councils, but what about smaller population areas? Do you happen to have any data on how many of the positions have been placed in populations, say, under 10,000?
I can get that for you. Sorry, and I was wrong. It's 66%, not 61%. Yes, I can get the breakdown for you based on population, if you like.
Take that on notice.
Take it on notice.
That's fine. Thank you. Thanks very much for that. Mr. Whitworth, just coming back to you, and again talking about programs that have been rolled out. The Central Darling Shire, which had been under administration for 12 years. 13 years. Well, good to see democracy restored. But the rural and remote council model that was put in place there, is it being considered for any other councils in regional or remote New South Wales?
Not at this point, for two reasons. One, the model itself requires a council to be in administration, and I'm pleased to say that we have no councils in administration.
And so that's not necessarily in administration for a certain period of time, just if it's in administration.
Just in administration, but it also needs to have a population base less than 5,000, but it's. I think there was, when the legislative change came through, there was a degree of concern that this is, a way of hiding a different model. Our ambition is that we can help these councils get, Central Darling was in administration for 13 years because the financial challenges that it faced as a remote council were so significant that it was unable to, the risk of having it come out of administration was too great. Yes. And so that's why we've used a model that is based on the Lord Howe Island board model, where it is a shared responsibility between communities and the state. We have supplemented Central Darling with a with a grants program. Correct me if I'm wrong, Ms. Hickey, $6 million over 2 years, to help its to help address some of the financial challenges that it has. We wouldn't, I wouldn't. I mean, there are a number of councils that start with B that would be going, hang on, we're remote too, but they have no concern from our perspective. Okay, and I note that the elections were only held on the 20th of September 2025, so again, I understand that it may be a little early to consider rolling the model out further, but there'll be a review on all of this. Is any of that planned? KPIs? How are we going to measure the success? How will that work? My memory of the provision is that we need to review the operation of the council, but what we're also doing, I suppose, using the grant process for Central Darling to see the success of that in terms of how it can use that money to address the financial challenges. We have a very, I think, quite an exciting council in terms of its diversity of views and opinions. There's youth, there's experience, there's knowledge of the local government systems, there's knowledge of local communities and what they need, both Aboriginal communities and pastoral communities. So I would like to think that we're able to check in and to support that. And obviously we continue to look at the operation of Central Darling. We have an internal monitoring process, obviously, for a council that we never intended to just create it and set it free. Yeah, we want to make sure that it's working well. Yeah, good. Thank you. And I've only got 25 seconds, so just quickly, back to the code of conduct and the briefing in the white paper, conflicts of interest and the manner in which they would be addressed from councillors, general managers, mayors, etc. That's part of that as well? Conflicts of interest, yes. But again, general managers, part of the staff code of conduct. Council laws will be part of the council law code of conduct. And Minister talked about wanting to align with the parliamentary and the approach for parliamentarians, which is being developed by the Collective Privileges Committee of the lower and upper houses. Okay, thank you.
Thank you. Dr. Cobb.
Thanks, Chair. I had a few questions about the candidate and councillor diversity report for 2024.
Yes. Miss Vanden Honor would be here to answer those questions, but she's unwell today, so I will be taking those. Yes. Okay.
The first question's a fairly broad one. We were supposed to have that report available, I think, by December last year. Where's it up to and when can we expect it?
It's in my intro.
Okay.
So it's imminent. It is in my intro. As I said, it is imminent. There have been a number of other issues that I've been working through, but I do feel like there probably are some key statistics that you probably would be interested in. I do know that we have not really changed the dial that much in terms of gender diversity. We have seen some improvement, but it's, I think the number of candidates have increased from 42.1 to 42.2, which is not really moving the dial. We do, I think, have more. Sorry, I am still trying to find it in my notes. We have more. People from Aboriginal and First Nations background. Again, not appreciably more, but we still are increasing. So that is good news as well.
Thank you. You've correctly predicted some of my interests there, particularly noting it's International Women's Day this week. Local government.
Hence my purple tie.
Noted and appreciated. Local government's still well behind state parliament in terms of representation of women. So we went from 39% women councillors in 2021 to 41%. I know in previous council elections there have been Office of Local Government initiatives, such as some workshops that were jointly funded with the Office of Women to host candidate information. Given the statistics that you've just read out that are obviously not noted that they're increasing, but not in a compelling way, not on a trajectory that's going to make a real difference, what kind of initiatives are in the works for the next council election?
Look, the next council election will be after a state election, so I can't really commit a future government to any funding in that sense. But I think this was the second. This was the second set of state government elections where there was funding given to Algwa and the name of the other organisation, but we did provide it to another organisation as well. Sorry, they will not be happy with me because I've forgotten their name. But they've run a number of workshops.
If I ask you what organisation it was, then you can take it on notice.
I can take it on notice. Thank you. Sorry.
You take yourself on notice.
Yes. And there are some spots where we feel that we can do better. I mean, Tamworth unfortunately has no female representative. I think that's disappointing, not to say anything about the candidates that were successful
Women for election.
in that election.
Yes, I was delighted to hear my colleague Ryan Brook at Tamworth Regional Council is attending the Algwa event. Noting that there are no women at Tamworth Council to actually attend.
And sorry, it was funding to Women for Election.
Okay, thank you.
I told you, didn't I?
I've previously asked questions about LGBTQI plus identity, and I now understand that that's not collected because it's not included in the Local Government General Regulation. Has there been any discussion about updating that to include LGBTQI status?
We will be doing. We have actually released a regulatory impact statement around the update to the regulation for elections. So we're going to take the Local Government Act the Local Government regulations and split them into three. One being putting all the election provisions into one regulation. We did put out the regulatory impact statement, but we haven't released the black letter law yet, and we were waiting for the outcome of the elections bill, local government elections bill. I would imagine that if we were to identify, so all of our diversity information comes from the essentially the statistical information that a candidate will self-nominate. So it is a case of really just updating the form to have that information available, but it will always be a self-nomination process. So I don't have any particular concern about doing that, but I think that I would like to take advice from the Electoral Commission as to whether that's something that has been a challenge for them. Obviously, we try and align the information that we collect on candidates at a council election with the information we collect on candidates for a state election process as well.
Okay, thank you. Look, I appreciate it's something you've got an open mind to doing, particularly now that questions about sexual orientation will be included in the Australian census.
Yes.
There's obviously a question for all government agencies whether they'll align with that. Thanks. I also wanted to ask a question about remuneration, noting the Minister's comments this morning, some of which I disagree with strongly, and I think when councillors aren't remunerated for the volume of work that they do, that impacts the diversity of the candidates that we get putting their hands up in local government. As part of this work that you've done with the diversity report, is there any consideration of the impact of remuneration on people who put their hand up to stand?
The Remuneration Tribunal is actively considering the submissions that it has received from councils for the 26-27 determination. That very issue around the link between remuneration, the conditions of being a councillor, around care for dependents, and the amount that a councillor receives as the fee that they obtain, and then the expenses policies that support those. The expenses policy isn't something that the Remuneration Tribunal can look at, but those other elements were certainly part of submissions that have been made. The Minister flagged, and it may be a bit of a revelation for people, that we have a new Remuneration Tribunal in Justice Schmidt, who is also the Parliamentary Remuneration Tribunal, and there are advisors. So Vic Smith, who is a former Mayor of South Sydney and a former Administrator of Walgett, is an advisor, and I continue in that role as being an advisor as well. So I can't talk on behalf of the tribunal, but obviously the submissions are certainly flagging that as an issue.
Okay, thank you. I'm pleased to hear that argument's been made and that it's under consideration. I will hand back to you, Chair.
Great, thank you. Just one last question in regard to Sydney dogs and cats. So overall, I know that originally they were given 12 million. Has any additional funding been allocated to deal with sort of all of these difficulties that have come up, or has it all still been sort of tried to get within that 12?
We have identified an additional $500,000, but we're also in the process of preparing submissions for a further amount to ensure that we can get this project finalised.
Okay, thank you. I also have some questions in regards to the puppy farm reforms. I was going to ask some questions regarding the number of breeders that have been approved to keep more than 20 female dogs.
So I'll ask Ms. Roman to answer that question.
Thank you.
That's 37 have been approved so far.
Sorry, can you repeat that?
There are
That's all right.
37 have been approved.
37. And is the time for applying for those exemptions closed?
So since
No.
it was
No is the short answer, because the way the legislation has been drafted, any exemption can be made at any point in time. So it's something that we're talking with our colleagues about, whether it can be updated at some point. So we continue to have that obligation to receive and assess applications.
Would they would be operating illegally though now if they haven't got an exemption? They can apply for an exemption, but as of today they would be operating illegally if they haven't got one yet.
Yes, and I have discussed that with the Secretary of DPIRD, so it's a conversation that's live at present.
Okay, great, thank you. I appreciate that. And were any breeders refused an exemption, or they didn't get the approval once they applied?
So we can refuse an exemption under two circumstances. The first being that they've got a criminal conviction for animal cruelty, and in which case, actually, if you've got a second, I can read out to you the conditions that are under the declaration, and it'll save a question or notice. So the declaration statement includes, I am not subject to a disqualification order or subject to an animal cruelty offence under the POCTA Act. I will, within 28 days, notify the Office of Local Government in writing if I am convicted of an animal cruelty offence under POCTA or become subject to a disqualification order or interim disqualification order under the Act, and all individuals involved in the management or control of the organisation, if appropriate, are not subject to a disqualification order or subject to an animal cruelty offence under POCTA. So at that, they don't really have the scope to even apply if they have a criminal conviction.
But it's based entirely on like a self-declaration at this point.
And we will also, we have an assessment panel, and we will have been consulting with the RSPCA to ensure that we have advice from that organisation on any animal welfare concerns. The legislation as drafted doesn't give us the ability to just refuse either. Yeah. So we need to go through a notice of intent that we are going to refuse because we're effectively taking away a right. So obviously we can't, and again, if we're going through that process, we need to provide natural justice to these people. So I'd rather not talk about the numbers that we have not yet determined for that reason.
Okay, so there's quite a few that are still under consideration.
There is a number. I don't really want to, but it's not. It's less than the number. It's far less than the number that's been approved.
Yeah. Okay. And so the 37 that have been approved, the RSPCA, as part of that process that you just described, Mr. Whitworth, they have clarified with the department that there's no criminal history.
For every single application, there's a long process where we do desktop research, comparing photos of their sites to the breeding code. We do get an independent criminal history check just overall. Then the number of dogs on the 24th of October 2024, which is the date of determination, compare that to the registry, ensure that all of the records are in alignment. So we go through all of that. Then the final stage is going to the RSPCA and AWL and saying, do you have anything to note here? And for those that have been approved, largely it's been all good, nothing to see here. If they have other comments, then we would say, look, let's can we have a further discussion about further inspections or a bit more information before we, and that's that process that Mr. Whitworth talked about.
And does it go to the police as well, given many of those cruelty issues were under the Crimes Act?
Sorry. I would expect that would be captured under the criminal history check, if anything was, I guess, prosecuted, but no, we haven't gone to the police specifically.
But you suspect it would have, so if the police prosecuted them for some of the cruelty offences that are applicable to stop them from breeding, you think that would come in through the...
Would be surprised that the RSPCA wouldn't be aware of those.
Yeah, there is a record-keeping issue with the police, the Animal Welfare League and the RSPCA, which, the RSPCA and others are quite open about. And it's just sort of, confidentiality issues between the departments, the fact that they're on completely different computer systems. And so, often the RSPCA and the Animal Welfare League may not necessarily be aware of what's happening with police cases and vice versa. But I'm happy for, maybe... if I could ask you to sort of look further into that and make sure that it would be captured under the process that Ms. Ryan has identified.
Yeah.
That'd be great. Thank you. And my office has been in contact with the department as well in regards to essentially buyers trying to find out if they're buying from a breeder that has an exemption or whether there's a problem. I know that a member of the public went to buy a puppy from a breeder. They saw that it was more than 20 dogs, but they couldn't get the information as to whether that person had an exemption or not, and they didn't quite know what to do with that information. What was the reason that these exemptions and the breeders themselves or their businesses weren't sort of identified in a list so that buyers could identify different breeders?
I feel like I need to refer that to my colleagues in DPIRD, because
sure.
that was part, this is an amendment to the Proctor Act. It was part of the Puppy Farm Act reforms that Minister Moriarty brought. I don't know whether they can help on that.
So I'd have to take that on notice in terms of the thinking behind publicising a list of who's got the exemptions. So.
Yeah, if you could, and I guess if you could take on notice as well, in Victoria where breeders can apply for an exemption, there's actually a list of the names of those breeders or their businesses, so that consumers in the market sort of know and can find that out. But in New South Wales, pardon me, the same doesn't exist, and so just trying to understand why New South Wales has got a different system to Victoria, and then I guess a further response around. No, I think that's fine. Thank you.
Thanks, Chair.
Sorry. The other thing I do want to know and understand around that is how that then works, kind of technically from an enforcement perspective. If, in the case that I just gave, the member of the public didn't know whether to contact the RSPCA and waste their time necessarily because they saw somebody that had clearly more than 20 female dogs, and they didn't know if that person was necessarily breaking the law or not. And so what would be the process for someone under this if it has to be enforced by the agencies and how they go about it when...
certainly we can look at that.
Thank you. I have also got some questions in regards to the companion animals grants. Am I able to get a list of each of the rescue groups that received funding and how much they received?
Yes. We can give that on notice. If that's okay.
Sure.
Can we just check the privacy
concerns?
I'll
just check. That's true.
I don't need names, I don't need addresses or anything like that. Just, I guess, preferably the names of the rescue organisations.
We'll just run it through legal to make sure we can release that information.
Or if we could just give it to you directly if anyone else is interested. Yes.
Yes, that would be great. Thank you. And so the idea at this point is not to make that public. Is that right?
Yes, I think that's right because we haven't checked about privacy.
Okay. I know previously they were made public in the last...
I was just thinking actually, so there is a requirement within 45 days to
publish any grants.
The grant outcomes, but I'm not sure what the detail is, so I'll have to get back to that. Yeah.
Thank you.
We'll comply with the grant guidelines is the answer.
Yes, that's it, Kirsten, sorry. Yes.
Thank you. And look, this is probably for on notice as well, but if any of this information's available now, that'd be fantastic. I wanted to find out how many groups actually applied in total for grants.
97.
97.
97 applications.
And of those, how many were given grants and how many missed out?
58 were successful.
Yeah.
So they were determined to merit funding.
Yeah.
And 39 were not.
Mm-hmm.
And the team are talking to they've offered any briefings to the unsuccessfuls to talk them through why. Mm-hmm. It seemed to be that a lot of them just didn't put detail in, and in fact that's where some of the successful candidates didn't get as much money either.
Mm-hmm.
So,
were there any candidates that got 100% of the grant that they
No,
requested?
everyone received partial funding.
Everyone received partial, thank you.
I think it's educative to understand that there was over $7 million sought
yes.
as part of these grants.
It's very, yeah, it just goes to show you the need.
Well, it does, but we also have 1.5 million next year, and we have 1.5 the year after, and 1.5 million the year after that too. So hopefully we will start to rebalance, and so that we're not getting the sugar hit and then the sugar decline, that we can start getting a more even allocation of funding.
Thank you.
I know OLG can't or cannot direct how a council spends its money or invests its funds. I was just wondering, does OLG offer guidance to councils on their fiduciary responsibilities? And the reason I ask that is, say, as an example, City of Sydney passed a motion acknowledging and supporting Rising Tide, but with that included a donation of 22,000. Then we know with that there's a protest where it's probably going to result in arrests. So is there a policy or guidance that OLG gives to councils? I know you can't say to them, you can't do that, but...
Well, I think the Act sets out principles of financial accountability, and we expect that councillors would be guided by those principles of financial accountability. But they're elected by their community to represent their community and the views of their community. So if a majority of the council believes that that's an appropriate thing to allocate their funds to, then that's what they have voted for. I have and frequently reminded councillor candidates for a councillor role that if you've got 11 councillors and 6 people vote one way and 5 the other, that's still a decision of the council.
There are specific requirements around grants and sponsorships as well, which councils must follow. They need a resolution of council to provide a grant or sponsorship. They can't just do it without that public resolution.
Okay, all right. Could I ask, like with the build to rent and the base rate, because what I understand is the build to rent developments are done as a single lot.
Yes.
Has OLG assessed, say, that rating arrangement and its impact on council revenue?
We identified as part of the government response that build to rent was one of the rating issues that we need to look at. Other rating issues include looking at the rates applying to renewable energy zones and renewable energy generators in renewable energy zones. The announcement of the expert advisory panel means that the work that we have been doing on different options for build to rent can be brought to that panel for a review and a perspective on whether changes to the Local Government Act would be appropriate. There is a fine line here. I think you don't want to, build to rent will provide the diversity of housing that we need. It's not going to be, and when I say diversity, I'm not talking about necessarily affordable housing, but it is certainly a diversity of housing in a good location. So we don't necessarily want to overrate it. We want to make sure that it is still a viable option and approach, but a principle that where you consume services, you should pay for them, should be a sort of underlying rationale for our rating approach.
Thank you.
Thank you. I'm just wanting to get a bit more information too about how the decisions were made in regards to sort of what percentage was actually given. I know you've given me a bit of an understanding of people who were unsuccessful, but what sort of process did you use to work out the percentage different groups should get?
So the panel assessed all of the applications and they went through them individually and then came together and assessed what, if say they asked for 100,000, they made a determination about how much they would be. And then the Minister then wanted other options, which is the 58. So then of the 58 that were found meritorious for funding, a percentage, we just worked it out so that they all got a percentage, basically.
Oh, so the panel worked out who should be included in this round.
And ranked them, yes.
Okay, and ranked them.
Yes.
Based on what were they ranking them?
They were based on the criteria within the guidelines. So, and when I say rank them, like not everyone asked for 100 and not, so they just ranked them based on what the amount was that they felt like that they thought would meet the criteria. And then when we spread it over a larger amount of organisations, then they got a percentage of that.
And what was the percentage?
Oh, I'd have to double check that.
We'll take that one on notice.
Yeah, thank you. And so that percentage was applied to every 58?
Yes.
Yeah.
Yes. So it was effectively a proportional reduction down.
Yeah, yeah.
I mean, this was a very challenging decision.
Oh, I know. Yeah.
I mean, this is loaves and fishes sort of exercise, and it is about wanting to make sure that these important organisations, even if there is some funding that we can give them that will help them supplement some of their own fundraising processes as well. But again, we come back to the importance of there will be funding available next, that we will put the funding round out within coming months for another round of funding.
Okay, when you say in coming months, are you?
This is funding for the 25-26 year, so we'll be putting funding out for the 26-27 year. So it would be preferable for us, and we've talked about this, to get those guidelines out as preferably before the end of June this year, so that we get more continuous funding.
Yeah. We do want to take some feedback about the guidelines as well. So.
And so it will just be the guidelines that come out in June. The actual process itself won't open then?
Well, the guidelines will be the process for which the funding will be open.
You won't be able to apply until the next
I won't be able to apply until when, sorry?
The next financial year.
Next financial year, thank you. Yeah. Well, that takes us to our afternoon tea break.
Had a busy afternoon, Mr. Donnelly.
What I might do, I know you've got some things that you want to put. I won't break our because we've only got a 15-minute break. But as soon as we come back at 3:45, I'll allow people to put some answers on notice if they've got some more information for this afternoon.
Sure.
Thank you. Thank you, and welcome back to Budget Estimates. I'll throw straight to the opposition.
Thank you. All right, I wanted to now turn to, say, the Red Fleet or the Rural Fire Service. And I know that there's been an audit and possible transfer under considerations, and councils are probably seeking assurance that they will not face further cost shifting. So I wondered, what guidance has OLG provided to council about managing financial exposure where the RFS directed maintenance exceeds allocations or reimbursements?
So you're asking me a question about, that's an accounting question rather than about the transfer of the asset.
Yeah.
And that
I think in terms of like giving councils assurance about that cash flow risk.
the cash flow risk being that if the council has been relying on the asset to offset any borrowing, capacity, and if the asset suddenly is removed, then they're no longer. Look,
Take it on notice?
Sorry?
You might take it on notice?
Well, we can take it on notice, but that's quite a. I don't quite know the answer to that. It's almost like, is that a decent colour of purple? The issue is going to be what are the consequences for councils in terms of their balance sheets of the loss of the assets, and at the moment that process is ongoing. I don't know what the loss of the asset will be for each individual council. I also know that the Audit Office has a view that, which is why they decided not to qualify a number of councils that, accounts that the impact is not a material impact. So at this point in time, I don't know what advice we can give them, but I will ask that be something that our code working group specifically look at.
Well, what about if the way it operates at present, where councils have, I suppose you'd say, they are legally invested in the councils, but the operational control and maintenance sits with RFS. But councils report cost overruns, reimbursement delays, and I suppose unplanned major repairs for assets they do not control. So this is, say, prior to any transfer being under consideration. Have councils reported to you that they're experiencing shortfalls in Red Fleet maintenance funding?
No, I've not had that be provided to me specifically. I don't know whether it's been provided to the department more generally, the office more generally, but I'd also say that councils are providing maintenance services for those, that's done under agreement, and that is really a matter for the councils to raise with the RFS.
Okay. So, but they don't report to you then, so sometimes, like they have that agreement with the RFS that sometimes the time frame for, when they've carried out the work and then when they're reimbursed, a period of time elapses where they don't, because they've paid the bill.
So it's a cash flow issue that you're now concerned about. I've not heard that councils will raise cash flow concerns with me about money coming from the state government on regular basis, whether it's transport grants or whether it's disaster recovery grants. But the specifics of the maintenance agreements between councils and the RFS is a matter for the RFS. You'd need to ask the RFS.
Okay, I might do that then. I then want to turn to, say, the special rate variations, and the Minister touched on it this morning in the session this morning. What progress has been made, because I asked about, the original sort of purpose of the special rate variations. Has there been any progress made in returning those special rate variations to their intended role?
The role of the expert advisory panel, one of the roles will be to look at both the comprehensive spending review and a revamp of the guidelines around special variations. At the moment, IPART operates under a set of guidelines for special variations that the Office of Local Government prepared some time ago. The intent, I suppose, is that the comprehensive spending review would be a way to effectively, my words, re-baseline the council's revenue and expenditure, and that special variations would become focused on either specific projects or specific places. So a central business district renewal program, for example. But the two will need to be meshed together. So it is one of the items that's on very early in the agenda for the expert advisory panel to consider.
Which was announced, what you said, not yesterday, the day before?
Yes, the membership of, yes.
So when will the panel hold its first meeting?
I would expect that it would be in the next 2 weeks.
Okay, so you'll have a fairly full agenda.
Yes.
With all the things that you've mentioned so far, you know, special rate variations.
We have six streams of work: rate reform, the comprehensive spending review, special variation, the audit of fees and charges, the upgrade or the review of the performance ratios and metrics, and the changes to accounting codes.
And have you decided on a priority list there, or?
We have a work program, but obviously I want to be able to discuss that work program with the
at your first meeting,
panel.
And how often would you envisage the panel meet?
I don't. Sorry, I just had this terrifying thought that it will need to be quite frequently, and my diary's going to get even worse. But we will leave that. I will discuss that with the panel. The idea would be that we will bring a number of papers to each panel meeting so that they can digest, give us suggestions and directions for change.
Yep. And how will industry bodies be engaged, or stakeholders?
The panel, and I think it's important to say this, and the Minister had flagged this for us, the panel is going to be about experts in local government finance and experts in the delivery of services in local government. It's not a stakeholder panel, because if it was a stakeholder panel, it would be put together differently.
Yeah.
So we will need to ensure that we have a stakeholder process to engage the great diversity of local government in New South Wales. The rural and remote councils in particular, for example, will have an entirely different set of financial circumstances, and we'll need to tap into the expertise and understanding of Warriner, Burke, Balranald, Central Darling, Broken Hill, as an example.
And how was the panel put together, or what was the criteria for selecting panel members?
The Minister appointed the panel.
The Minister. Okay. So I don't know, like, what's the process there? He just...
We provided a number of different names and options, and he came back to us with, his views, and we were able to mesh together and come up with the panel appointment.
Okay. Right.
Through the miracles of technology, I can tell you that there will be monthly meetings.
And okay. And will federal financial assistance grants be on the agenda, or that's
not really within
part
the
of that
remit
remit?
of the. I mean, the financial assistance grants, or FA grants, are really there are two questions, I suppose. Once New South Wales is given its share, how is that
That pie
allocated?
divided,
And,
yeah.
and as a former Grants Commission member yourself, you know that we have a process, and we want to revisit that to make it clearer and more transparent. And to, we've instituted a negative floor, for example, which means some councils this year actually received less and other councils received more. That's going to be an ongoing challenge. The other question for FA grants is there a way to increase the pie in terms of the amount of money coming not just to New South Wales but to the other states as well? So I can I can inform the committee that the issue is regularly discussed at local government minister forums, and I will not let an opportunity go past when I have a senior Commonwealth public servant talking about local government issues to remind them that a greater share of GDP allocated to local government will be an important role for. And it's not just about making councils more financially sustainable, it's about delivering on housing affordability, it's about delivering on increasing resilience to climate change, it's about better managing recovery from disasters and so on.
And are you aware what advocacy has been undertaken to increase the financial assistance grants?
I am aware that the Minister has made representation to his colleague, Minister McBain. The New South Wales Government submission to the Commonwealth inquiry into council financial sustainability flags the importance of increasing the financial assistance grants as an important way of achieving financial sustainability.
And has the Minister spoken or raised this issue with other government ministers besides?
I can't speak for what the Minister has or hasn't done when he's talking to other government ministers.
And is the advocacy coordinated with other states? Are you aware? Or?
Look, from my perspective as a senior officer that meets on a regular basis, but a quarterly basis with my colleagues from other states, we generally discuss it at our meetings. So if that's a coordinated approach, yes, certainly is always something that is flagged as being part of the conversations that local government minister forums will entail. I think there is a difference in the concept of advocacy from the local government sector and the concept of advocacy from the state government sector. We frequently and politely raise the importance of this funding being increased, where we won't necessarily revert to more campaign-based styles of advocacy, however.
And has the Minister, indicated what the response has been when he's, talking with his colleagues and the Federal Minister?
Look, I don't know what response the Minister has had, and again, I don't really want to speak on his behalf. No. These are questions for him. I can tell you that the Commonwealth bureaucrats' perspective is that there are a lot of demands on the Commonwealth budget, and there are commitments to increases in funding and funding challenges for the Commonwealth, NDIS, defence, education, health, etc. So this is one of the challenges for every level of government, the amount of money, the revenue that they can reasonably tax from the community is finite.
And you mentioned before risk governance and cyber security as one of the priorities that you're working on. And I know that Audit Office identified governance weaknesses and I guess preparation in terms of AI being a cyber risk. Has the OLG, or has there been any implementation of any of the Auditor General's recommendations?
Well, the Auditor General has only just made those recommendations, but I'll let Ms Hickey talk to you about that.
So we have talked to our colleagues in Cybersecurity New South Wales, and we do take their advice, as well as the Australian Signals Directorate, who also provides advice for councils as well. And so we are looking at whether the current framework that's in place for New South Wales government, maybe a more streamlined version for councils, can be adapted, or basically they've offered to help us with some webinars and just talking to council. So
And so,
do that. Sorry, I
Right.
should say that was at officer level, that was still going around, so it's not definite. Yeah.
yeah, and are you aware of how many councils already have, say, an AI governance framework in place?
No, it's a relatively new thing, so we
New
don't.
thing. And will you be, I don't know, do you survey, or how would you, if you wanted to find out that, how would you, would it be a survey?
So we do a financial return every year, and we
Mhm.
can put some questions in that.
So it'd be
that could
through
be
that
one of the questions
financial
we answer,
return.
yeah.
And have you identified any cybersecurity weaknesses within?
I am aware of some breaches that Cybersecurity New South Wales told us about, but that's not something that comes to us, really.
So that's probably a matter to put to Cybersecurity
Security.
New South
Yeah.
Wales as part of the reporting obligations that councils have through
And
the
so then
guidelines.
there'd be, say, a sector-wide AI cyber framework being developed, which you would
That's
then-
what the Auditor General has recommended,
Yeah.
so we're still looking at what it would look like.
And it's not cyber and AI combined, it's cyber and a separate framework for AI and the use of AI.
Right, okay. And also in an Auditor General report, there was, and I touched on this morning with the Minister with regard to financial reporting. Why do you think the progress on that, on reducing, say, the financial reporting burden, has been slow to date, or not hastened?
I feel like I answered this morning, so I'll probably rephrase what I've or repass what I've said. That
Thank you.
there is essentially a difference of opinion between the Audit Office and my colleagues in the queue as to the role and importance of special purpose statements for water and sewer entities that councils run. The queue, I think, want to have them. Audit Office don't. And we are using the Code Working Group the Local Government Accounting Code Working Group to have a mechanism or a venue or a forum to discuss that, and whether there would still be a need to report on the finances and the accounts of the water entities as part of the broader council reports, but whether having a special set of accounts is necessary. So this has been something that the Audit Office has raised with us a number of times. This is, the Audit Office did this as part of the local government report. I remind you that the regulation of the water entities of councils is under the jurisdiction of the Minister for Water. So even though it's in the local government report, it's not necessarily an OLG issue, and we find ourselves a little bit being the referee between two counter views that both have equal authority and value, and we're trying to resolve that.
So it wouldn't be part of your expert panel discussions then?
No, it may come up. Not trying to exclude it out of the conversation, but it's quite a specific issue that the Audit Office has been raising. We continue to look to see how the accounting code can be made slimmer.
Yeah.
And I should say that the expert advisory panel is also going to have the valuable input of the valuable input of the Audit Office and my colleagues from my part as observers. So there will be valuable insights contributed there. I think it's, and just teams identified that it's really a discussion about removing information, so removing the special purpose financial statements, balanced against the value of having that information available, particularly for a regulator, being the Q, in order for them to fulfil their function.
Okay. Do you think New South Wales councils face greater requirements than, say, other jurisdictions in this area?
I have heard that commentary. I haven't seen the evidence for that, which doesn't mean to say that, you know, someone's not working on putting something in front of me as we speak. I can't. I mean, one of the things that I know about local government across the nation is that not only is every council different, but every state is different in how they regulate local government. So sometimes some of those state-to-state comparisons are quite challenging.
Yeah. Thank you.
Thank you, and my apologies, Mr Whitworth. I did say after the break I'd give you an opportunity, so I'll give you that now, and my apologies, I forgot.
Okay, thank you. There are probably a number of things at the indulgence of my secretary who really, you know, it's possible that I can probably deal with a number of these things through questions on notice, but I probably just want to flag for you that we have looked at the Port Stephens Council issue. The council has acknowledged that they can be doing better in terms of their phone contact and their availability, but they are quite confident that they are undertaking their role and function appropriately, but they are happy for us to use our powers under Section 734A of the Local Government Act to undertake preliminary inquiries. Regarding, Ms Overall, your comment about the providing the SOMEVA proposal, I have quickly read that briefing note. It's tentatively putting two words together and trying to create a meaning that shouldn't exist. I would probably have counselled the councillor to seek advice from the General Manager, and the General Manager would have told them that that briefing note really doesn't have any impact on their notice of motion and to continue. We have no formal inquiries that we have made about Hawkesbury Council. In terms of Uralla, and this was a question from Dr. Conn, Uralla didn't have enough, Uralla didn't have an election, so to speak. And so as a result of that, their election costs were quite minimal, but now they need to have a by-election because of the unfortunate death of one of their councillors, and that means that they have two wards. That means that it's a relatively that they need the whole ward to vote on that, which is why that cost figure has been identified. But the Electoral Commission is looking at that quote that they've provided, and I think that they've even brought it down to somewhere close to 100,000 rather than the 140,000 that was quoted. We have 56 staff in Nowra that are allocated to the Nowra office, and just in terms of Madam Chair, your question around the criminal check. So the criminal check process that we have scans police records.
Okay, great, fantastic, thank you. Mr. Whitworth, I've got some questions, actually some further questions on pounds. You told me that at last estimates that following the parliamentary inquiry into pounds, you'd be working on a code for pounds. Is there any update on potential progression into a code for pounds?
We discussed that earlier, so that's the rehoming pound. Sorry, the pound code that my colleagues, Ms Connell and Mr Day, discussed with Dr Conn, and the consultation.
Oh, the one it's slightly behind, and so we've started.
Oh, sorry, no, that
was the breeding code. I thought.
Oh, sorry, the breeding code, not the.
We did discuss
we did discuss the pound code, and that it is a priority, but it is on our work program. But we are, I can't give you a date for it.
Can't give you time. Is there any specific funding that will be needed for that? Have you identified that it needs money or to review?
I think, as I flagged, I'm more looking at the companion, as I gave evidence before, that the review of the Companion Animals Act will, if we if we increase responsibilities on pet owners here to address issues around cats that are potentially creating concern for what, cats are predatory animals and will, so if we're trying to contain the predatory nature of cats, if we're trying to reduce the number of dogs that are dangerous, then there may well be a consequence for the rehoming network and the pound network, and we have to be talking about an increasing number or an increasing funding arrangement for the rehoming and the pound network, which will also mean that we need to talk about appropriate standards. So in my mind, I see them all as being linked together. So if you pull one lever, you're going to have an impact on another lever.
And does that relate to our conversation in the last budget estimates as well? You said we probably need to be thinking about how do we incentivise councils to improve the operation of their pounds, both from a regulatory perspective and an incentive perspective. Is that sort of part of that puzzle as well, as to making sure that there's funding for pounds to be able to do that work?
Sorry, didn't mean to interrupt, but yes, you're absolutely, yes, because it would be if we're talking about increasing the standards or, setting clear standards around the expectation for what a humanely operated pound looks like, then there will be some councils that will invariably come to us and say, either now or in the future, we need some funding to assist us to get it to an upgraded standard. So, but that will be a matter for the government to make a decision on when they consider the companion animal reforms.
Okay, thank you. And in regards to pound euthanasias, and I know we've talked about this a little bit before, but I'm just wondering if there's any work that's happening within RLG to target specific councils that are coming through consistently with extremely high euthanasia rates. I know there's some councils, for example, with Burwood, for example, had a 100% euthanasia rate of cats. Does that get flagged with you, and is there any sort of ability to do work with those councils to see what's going wrong?
Look, it does not get flagged with me at the moment. We are, I think you've heard that we are, under the pump just to get the pound data out. It is, people have made a lot of, that we've increased the size and number of the Office of Local Government. I still feel like there is still so much work and there's still so few people, and we are still trying to make, in the companion animal space, we're still dealing with very large numbers of phone calls about the pet registry, and we're dealing with numbers of callers around breeder identification numbers, the way in which we are to effect reform. Yes, always wanted to get to a more data-driven environment. Ms Hickey knows that, I keep saying I want to get better analysis, processes going, and has put on some data and analysts specifically to help us. We just haven't started making those connections yet.
Thank you. And in regards to any changes that are being proposed in regards to what councils do with stray cats, is any of that coming out of the RSPCA's decision to no longer accept stray cats? Is that impacting councils, and is that causing problems that you're hearing from a council level?
I have not heard any specific issues. That's not to say that it has been raised.
It hasn't been raised, but I would expect that there's naturally some impact there.
Thank you. And I've just got a question. Ms. Roman, I just wanted to get a broad update on the work that you've been doing as the new Director for Companion Animals Policies and Programs, and just get an understanding of where the focus areas are for you sort of going forward.
Yes, certainly. So a large part of my role is really scoping out the breadth of issues that relate to companion animals, far more than I think we all were really aware of. When you take all the little bits out from the various parts of the department and put them into one spot, it's a lot clearer. So I would view them in 4 core streams. We've got the pet registry helpline. So you're probably very familiar already with the nature of that registry and the various platforms that feed into that network. So naturally we need to provide a lot of support for that. So that's a really important, critical piece of work, and it's the direct engagement with breeders, buyers, councils, vets. Everybody reaches out there. Then we've got our systems functionality and capability. So previously, and this is one of the good things about the new roles in the team, we've got investment now in roles that understand the platforms. So should we be in a position to develop further or engage with other vendors, we'll have appropriately technically skilled people who can engage in a like-to-like basis, as opposed to, I think, a more robust management approach. Then we've got the policy piece and the programs piece. So the policy team's looking at the Companion Animal Act review, and the programs piece is engagement with councils, rehoming orgs, all of the things that we would have loved to have done and couldn't do. I feel that we could have 100 people in the team and still have more that we could do and do bigger and better, but with the team that we have and are ultimately trying to staff, once we've got a full complement, there'll be a lot of planning, prioritising, obviously within the corporate priorities and government priorities, but yeah, there's a lot.
Thank you. I really appreciate that. And I've just got a couple of questions to finish off around the Red Fleet. I'm wondering if the Office of Local Government provides any guidance to councils regarding the financial exposure of RF-directed Red Fleet maintenance and repairs, for example.
I think I'd best refer to the answer that I provided to Ms McDonald. You've obviously got people giving you the same questions. That there is a process going on at the moment being run by RFS about the identification of the condition of the assets ahead of a process of transfer. If there is a risk to councils' balance sheets as a result of assets coming off their balance sheet, then that's something that OLG will be part of that process and have forewarning of. If councils are concerned that the funding for the maintenance that they have through their existing agreements with RFS are problematic, then they need to go to RFS, or if you want to look for someone to be accountable, that's a question for RFS, it's not a question for us, because we have no visibility over those agreements.
Thank you. And sort of through that process, and apologies if I am on repeat, sometimes we're working twice at the same time, but will you have an understanding of the number of councils that are affected if there is a shortfall?
When you say a shortfall, I don't know what you mean by that.
If there's a shortfall in regards to the budget or reimbursement in regards to what those councils actually require, will you have an understanding of how many councils may be affected if there is going to be a shortfall?
This is if it's a funding agreement, if it's a funding issue around maintenance, I don't have any visibility on that, and those matters need to be raised with the RFS. If we're talking about the asset impact of the asset, a balance sheet impact of an asset leaving a council's books, I mean, there has been a concerted campaign by New South Wales councils to say that those assets never really existed on their books anyway, and that they actually didn't put them on their books, and that led it to them being qualified. I would find it quite unusual that those councils would then turn around and say, are you going to pay us money for an asset that we said was never on our books in the first place and we didn't count?
I'm not really asking you sort of whether you're making sure that there's money for those councils. Yeah. I think the question was more about if there are councils potentially affected or impacted, whether you would sort of have any understanding of which the councils those would be and whether OLG can provide any kind of, not financial support, but if there is something.
There may well be a situation where those councils that have had the assets on their balance sheets and having them transferred across will lose the value of the asset. Now, that will be a non-cash impact.
No, that's right.
We will certainly be working with RFS to understand that, and whether there is a special notation as part of the accounting code, we will also look at that. But at this point in time, it's really dependent on the RFS to undertake the condition assessments and understand what the value of the assets are.
And then they will be providing you with information once that's done? Is that your understanding?
I would expect that they will consult with us once that's done, yes.
Okay, thank you. The opposition.
Thank you, Chair. Well, how are we with time? To quote Tom Gleeson, we've whipped through their questions, now let's whip through mine. Following up on the discussion of the Red Fleet, and don't worry, you can be assured that my questions will definitely be a different tack. Mr Whitworth, what then is the OLG's position on cost shifting?
Gee, that's a philosophical question, I think. What sort of can you narrow it down for me in terms of?
Not really. Do you back the councils in their significant concerns about what LG New South Wales states to be significant cost shifting with figures attached, and then the Minister's position this morning suggesting to a degree it's a bit overblown, not quite right?
Can I just take my point, not to be disruptive, but just the matter of seeking to draw out a response on a policy position from the witnesses before us. It's very much a matter of, to the Minister, to deal with matters of policy.
Certainly, and to the point of order, I do understand, and I don't want Mr Whitworth to address the Minister's position, but I'm asking for the OLG's position.
Yeah, so I just think
position is the position of the Minister.
I understand the point of order. Yeah, I understand.
They are abutting the matters. I understand that.
Look, let me rephrase.
Thank you. Yeah, maybe perhaps if the member could rephrase.
Let me rephrase. How does the OLG address or look at the information that's put forward by Local Government New South Wales in terms of the continuing, even if it's perceived, negative impact and burden on councils of real or perceived cost shifting?
So,
again, probably a little bit philosophical, but
yes,
you get where I'm going.
It is a little bit philosophical. There are perspectives of that report that I believe have some credibility. What I will say is that the issue of how to set rates and the issues and the cost pressures that councils face are matters that IPART does examine, and this is me giving my IPART colleagues a bit of a heads up that I'm actually going to throw to them.
Yeah, that's good. I've got questions for them too. So.
Because the things that the Local Government New South Wales report does refer to are actually matters that the rate cap has identified an opportunity to increase rates to accommodate that. There are other elements where, the New South Wales Government will argue that the role that we play in the provision of healthcare and education, is a cost shift from the federal government, and councils will argue that some of the things that they do in terms of aged care, stepping in, is a cost shift as well. But they're all elections that are made by those governments. So this is why I'm quite grateful for Mr Donnelly's perspective on this as a point of order, because it's a political question. What I can tell you is that where it has been possible to identify a direct throughput then I believe IPART has sought to do that. And Mr. Nichols, did you have a comment that you'd like to make?
Thanks, Mr. Whitworth. Exactly to that point, in 2023, IPART introduced a number of changes to the rate peg methodology. Some of those were to introduce more forward-looking approaches to the costs that councils face. But one of the things that we introduced was a council reference group. It's a group that is represented from within the local government sector, representatives of Local Government New South Wales and OLG, as well as IPART representatives. That group is a pragmatic, hands-on group that looks at all of the costs that councils are currently facing. One of the improvements that we've made to the rate peg methodology now is a much more tailored approach, council by council. So once upon a time you would have seen sort of like very general rate pegs across the board. Now you'll see a list where there's a unique rate peg for every single council. And part of that process is we identify any costs that have emerged that are new, and we examine that through that very consultative forum to consider whether they should be passed on. To give you a very practical example, in the last 12 months, the New South Wales Government introduced a new dam safety levy, for example, and some councils that have dams now have to pay that levy, but not all councils. Our new tailored approach means that we have been able to examine and work out what those costs are on a council by council basis and appropriately include that in the rate peg. We've done the same with the emergency services levy. In the last 12 months, we've introduced changes to the way we are now enabling councils to collect election costs, and that reference group has a standing agenda of things that we're looking at. For example, coming into this year, a common issue that has arisen, and it's arisen in the Auditor General's report, is cybersecurity and how might we address those issues. So there's definitely a much more proactive way now that we have introduced those changes. As part of our consultative approach, we've also introduced an annual ratepayers forum. So we also go and ask people who are representative of the ratepayer base to get their input on these changes, so that what we now do when we introduce the rate peg is have something that is very thoroughly consulted and engaged on, including where there are concerns about these costs that have been introduced. We are just revisiting the terms of reference of that group, and I'm pleased to advise that the Country Mayors Association will be coming to also now join that group to ensure that rural and regional areas are even better represented, even though we have a number of rural members of that group as well. So where there are sort of unique differences between country councils and city councils, we're able to reflect that much more effectively now through the new approach to rate peg. So it's not a panacea to all of the issues that you're raising, but certainly it's a step in the right direction.
Thank you, Mr. Nichols, and that's exactly the point that I was about to raise. And to come back to your point, Mr. Whitworth, not a matter of being political. I mean, the question is simply getting to the fact, which you also articulated, that there are still things to be worked through, and as you have pointed out, that are creating tension points. And to come to your point there, Mr. Nichols, that's right, that it's progressing, but obviously the fact that special rate variations, for example, are still being looked at being implemented, 10 that we've heard currently, means that there's still work to be done in this space. But it is good to see that this is going on. One of the things that, well, two of the things that I want to look at there is with this new methodology, and that includes this population factor that's now being looked at. That's correct? That's part of the new methodology?
That's correct.
But so for regional councils with flat or declining populations, that still remains an issue?
We don't subtract with the population factor, we only add. Right. So where councils are facing increases in population, it came up in the earlier questions around things like build to rent, where you now have an influx of people coming into a particular council area but are not contributing to the rate base. Mm-hmm. The population factor is designed to allow for an adjustment so that the council is able to recover funding for the extra services that they have to provide to that population, even though those people aren't themselves contributing to the rate base. So it does have the effect of distributing the cost to the entire community. So it's not a perfect solution, but it means that councils are at least not worse off as a result of those new people coming into the area, except there's a slight time lag. So we use ABS data, so sometimes it's a couple of years lag, but we don't do the reverse. So we take a view that if you have a community that is seeing population losses, we're not about trying to reduce their revenue base.
Okay.
So it is one way. The only time we've ever made an adjustment negatively was after COVID. There was some sort of, and I don't want to get technical, but some unusual population movements that occurred as a result of people moving in and out of the CBD of Sydney and things like that required a little bit of a rebase.
Mm-hmm.
But that was for quite sort of technical reasons. We certainly don't, as a matter of policy, penalise councils that are seeing reductions in their number of ratepayers.
Okay, thank you. That's very interesting to know. Now, you also referenced, and talking about lag, the emergency services levy. The adjustment is based on the previous year's data, and that means that councils who have already budgeted this year, they are impacted in the immediate.
Yes, there's a small cash flow issue with it. That arises in two respects. The first is that just due to the vagaries of the time frame in which the budgets that are associated with the ESL are published don't line up with the time frames for councils to exhibit and publish their rates. So inevitably there is a sort of a 1 year lag, and that's just a product of timing, which is certainly on our agenda, but it's something where we would need other parts of government to do things slightly differently in order to achieve more alignment. The second part of it is catch-up, and it came up again earlier in the evidence or the questions today around councils that now have the extra cost as a result of the removal of the government subsidy. We are in the process of transitioning councils to a cost recovery for that cost, but we're not hitting ratepayers all at once. We're doing it in a staged way. Each council's slightly different, so some councils that we've already caught up in full, but if you look sort of on averages, we're about 75% through the process of catching up councils for the costs associated with the removal of that subsidy.
Okay. And so, Mr. Whitworth, on that basis and the lag and the crossover and some councils that are detrimentally impacted by it, is there any talk of support or assistance in the interim?
The emergency services levy is a matter that the Treasurer has made a number of announcements on. Those questions are best directed to the Treasury and the Treasurer.
Okay, that's fine. Can do that as it's up to him, no doubt. Thank you, Mr. Nichols. That was very, very helpful. Mr. Whitworth, back to you on the financial sustainability inquiry and some of the proposed measures to emerge from it. Again, concerns that, while it, it's being well accepted broadly, some of the things that could potentially add to councils' administrative burdens, things like the comprehensive spending review before special rate variations, are these elements that are being raised that are still, again, causing some tensions, being taken into account and looked at to find the best way forward?
I don't perhaps accept the couple of things there. One, the comprehensive spending review and the special variation are not connected. So we want to create a situation where special variations are about individual projects or individual precincts. At the moment, special rate variations are being used as a way of rebaselining a budget, but IPART is only able to look at the additional spend that will be coming out of the special rate variation, rather than has the council comprehensively reviewed its expenditure. So the comprehensive spending review is a different way of rebaselining, and what we are effectively saying to councils is and I said it before, the amount of money that you can reasonably expect to recover through rates is finite, you need to be aware of your community's capacity to pay. Therefore, you can't keep looking to increase rates. You've also got to go to the community and say, here is how we are trimming our expenditure, and here is how we will be asking for more money for you as a result.
And I understand that, and again, don't necessarily disagree, but I guess moving away from that example then, the additional potential administrative burdens on councils, particularly regional and rural councils, support opportunity to see that better addressed. Clearly it is being raised as a concern. So again,
so
you're suggesting that they don't have
no.
anything to worry about.
I mean, it's an interesting policy conundrum that you're presenting, because people are upset about the special rate variations have been. Sorry, if you don't mind, I wouldn't mind expanding on this, because it's people.
That's fine. It's like, as long as it's like, I mean, it doesn't have to be specifically narrowed to the special rate variations. That was one of the examples here, but I guess the administrative burden. Growing administrative burden more broadly as well.
Okay, so I do want to try and, I'll go quite wide. We want to try and make sure that the data burdens on councils are reduced. I have given my team, regular, commentary about how do we make it easier to do one of the important things that we need to do, which is collect information from councils so we can regulate them. How do we make that easier? We also want to look at how do we make sure that the accounting process is simpler and more straightforward for them, and that the delivery of their accounts is not a difficult process. And we also want to look at how their value, and part of the challenges with the accounting timeframes is the valuation of their assets and the question of depreciation. We're also looking at, are there better and easier ways to value assets so that they can be reflected in the balance sheet of a council without it having to be a torturous revaluation process?
Well, that's all good, Mr. Whitworth, because you've answered the question then. That is how you are looking to address the concerns that if they're being put forward by councils and local government New South Wales when it comes to administrative burden. That's great. It's like it's movement forward. So we're on the same page.
I feel like you're praising me.
No, I don't think so. I think you...
No, I didn't think the tone suggested that you were.
Well, it's like, don't misread the tone. It's like you'll know if there's tone, trust me.
Hansard doesn't record tone, so...
Yeah, that's right. So don't worry, you'll know tone. Ask my sons. Just coming to disaster recovery funding, and again, local government New South Wales putting out their serious concerns. And again, coming back to the serious financial strain, we all acknowledge that councils are under. But when you've got like the Mid-Coast Council area with $232 million worth of impacts, they've spent $42 million. So far, they've only received $6.1 million. Kempsey Shire Council saw $115 million in impact. So far, they've only received $5.7 million. How's OLG advocating or assisting to expedite this? We're putting a bit of pressure on to say, come on, this doesn't help them.
Look, it's one of the reasons why I am a member of the Disaster Recovery, the DRFA board that the Reconstruction Authority runs. But the Reconstruction Authority is also faced with challenging circumstances in that this is the nature of the Commonwealth, state, local council interaction. Councils are at the brunt of disasters. Both they happen in their area, they need to do the response, they go and they spend money. If it's category A or category B, they know they can go and spend money relatively straight away, but they then need to recoup those costs, and the process of recoupment involves multiple processes of grant assurance and multiple processes of audits from both the state and the Commonwealth government. The state is struggling to obtain its funding allocation from the Commonwealth so that we can then pass that on to the states. So as the Office of Local Government, what I do is to make sure that I can assist with those to bring forward an awareness of those councils that struggle from a financial or a cash flow perspective, to also, continue to advocate for a stronger role in disaster adaptation, which is spending on more resilient infrastructure up front.
Yes.
And that's something that everyone aspires to, but it's challenging to get to that point. And I've got to say, though, that specific questions about funding allocations and funding cash flow issues are really matters for the Reconstruction
of course,
Authority.
but once again, I mean, you've presented the position there well, that you are trying to ensure that those councils are receiving some level of prioritisation in terms of you acknowledging that there are some particularly impacted through all of this. So again, that's the advocacy role in that. And yes, just coming to your point there about the ongoing impacts from natural disasters, that there do remain issues with councils being able to do that significant preventative maintenance, introducing measures, etc. And again, that comes back to largely, I would expect, the funding and the opportunity of finances around that as well.
Yes.
Okay. Just quickly turn to a couple of housing, please, that we did touch on previously. Housing targets, from the government are extensive. How many councils are on track to meet their 2029 housing targets?
That would be a question for the Minister for Planning. The Minister for Planning sets the housing targets.
You're not able to answer how many councils are on track for it?
No, that's the question for the Minister for Planning.
Okay. What about voluntary planning agreements?
Again, that's would fall into the Minister for Planning.
Well, I'll try my luck on this one then, shall I? Does the OLG have a view about the 7-Eleven developer contributions, and if the manner in which they're used should continue to be so restrictive?
The second part of your question is really a policy issue for planning, because 7-Eleven is 7-Eleven, 712 voluntary planning agreements are imposed under the Environmental Planning Assessment Act. What we have introduced as part of our quarterly budget review statement is for councils is a clearer and better understanding as to how much money they are obtaining through development contributions, and we hope to utilise that to have a better understanding as to the throughput of their spending. Now, we know that some councils have pretty much the same money in their accounts from the beginning of the year to the end of the year, but they've actually spent the money that was there at the beginning, and they've just received the same amount of money because they've got a consistent development rate and a consistent infrastructure rate. There are also other councils that they don't spend that much. They receive contributions, and the amount that they have pooled is growing. So we hope that our data will start to identify that, and we'll work with my planning colleagues, and my secretary is also the planning secretary, to try and come up with some policy levers to see that money is expended so that we can see infrastructure that will facilitate the delivery of more diverse and greater amounts of housing.
Of course, and exactly. Staying on track to meet their housing targets needs all of that surrounding it as well. So again, thank you. Now, what about from a local government perspective, the current waste strategy and the waste levy?
Again, that's a matter for the Minister for the Environment. The Environment Protection Authority sets that waste levy.
Okay, well, let's qualify the question then. Is it working effectively from the perspective of local councils?
I'm the regulator of local councils. I'm not their advocate.
Okay.
I'm a voice within state government to make sure.
Thank you. It's like I'm trying to formulate then how the expression of concern to you, or maybe they're saying like it's all on track. Again, I'm hearing from councils about the impacts and problems surrounding the waste strategy and levy from them attempting to fulfil their roles. So is the OLG hearing something similar? Again, is it being presented for review, or has it been identified? You know, clearly it's a problem from council's perspective.
I mean, I certainly hear those perspectives from general managers, and I respectfully say you've got to raise that with the EPA, and that they have undertaken a review of the waste levy and that waste levy process, and I'm not aware as to the status of it yet, but it is certainly something that we are aware was going on. I mean, I think the important thing about the waste levy is it's a policy lever to reduce the amount of waste by trying to set price signals.
Yes. But
that's the intent.
Yes.
Whether that is what's happening, and
yes,
we are aware of. I mean, I had to deal with some of the consequences of that price signal process failing in a cross-border environment. So, which we have flagged that for the EPA for their information.
Okay. Good, and again, trust me, Mr. Whitworth, I'd love to have the Minister here so that I could be having these conversations with him as well, but he didn't take up my invitation to stay for the rest of the afternoon, so very busy man. So I'll come to a final one for me then, please, and again, it may be a difficult one to answer. It was one that I had wanted to raise with the Minister, but New South Wales war widows and war widowers, when it comes to the veterans council rate concession and how they're being impacted if they are the spouse of a veteran who then dies and they're no longer available, no longer have the opportunity to apply for the concession. Again, from the OLG's perspective, has there been any consideration or are you aware of anything that might be being looked at in terms of whether that can be addressed, is being addressed, is a question that's been posed?
So the short answer is yes. We utilise the Commonwealth definition of a pensioner, and we're aware of a concern about war widows. Mm-hmm. We have I talked earlier today about the review of the regulation that we have on foot. So that would provide us, the definition of pensioner is drawn from the Commonwealth definition but set in New South Wales based on the in our local government regulation. It does give us an opportunity to examine that, but that also comes at a cost, so we'll need to put a proposition to government that if we change the definition, we'll need to have an understanding as to what the financial implication of that will be.
Okay, but it's, again, a work in progress at the very least. Okay, thank you. Well, I've got 51 seconds and just one very, very quick one for Ms Connell, please, about pest and weed management for councils, and, has there been any uplift in funding around all of that? And I am kind of specifically looking at weed management, knowing the issues that they face in areas like Monero and Lovegrass. I'm quite the Lovegrass expert.
Yes, Ms Averill, I'd refer you to the committee hearing on Monday when matters under the Biosecurity Act will be dealt with. So we'll be reappearing again, I think, at committee floor.
Great, thank you. Okay. There you go.
Wow, you did it in your
Painless.
11 seconds left.
Well, there is another.
I have just a few, just with regard to, say, the capital expenditure guidelines. They're more than 15 years old. Is there going to be a review take place of those guidelines?
Yes, Ms Hickey can talk to that.
I was just going to say yes. Yes, the Minister has asked us to look into that, and we've been speaking with colleagues at Infrastructure New South Wales and other agencies, so we're putting some options to him. Yeah.
And is there a time frame?
I think the Minister wants it pretty quickly, Yeah.
But
it's not easy to do either.
No.
And the Auditor General's report did flag this as an issue, and that's only
Yes.
just come out. But we were working on this beforehand.
Yep.
But it will also mean quite a significant change in the way that councils prepare themselves to undertake capital projects
And so
and get
will
them
that
assured.
include capability frameworks as part of in that development of or
Yes.
review of the guidelines? Okay.
Yes.
Which then brings me to say questions of say infrastructure backlogs, and you might not be able to answer this because some of the infrastructure is to do with water, so it might be, but a lot of councils operate water in particularly in rural and regional areas. Do you accept that there is a large backlog of infrastructure in rural and regional New South Wales?
I think that particular comment was made specifically about water infrastructure, so I don't, and that's not within my area of responsibility.
Right, okay. So then my next question, how many councils operate water utilities?
We can take that one on notice for you.
Yeah, and then probably operate them at a loss? On notice?
Again, we'll take that on notice. I'm not sure whether we would, I mean, that this goes to the special purpose financial statements and whether a council operates, at them at a loss or not, but we'll take that on notice for you.
And then I this might be a hypothetical, so... No, so well, maybe I'll ask it anyway, and then you can
exactly.
How sustainable is reliance on grant funding? I suppose how long is a piece of string?
Yes.
Yes.
Yes. If you take the financial assistance grants out of the conversation because they're a different type of grant, then it is a challenge. If councils are structuring their capital renewal based on grants, then they're not doing a good job in terms of managing their depreciation and their investment into the future.
Sometimes that's true because sometimes the cost blowout of projects, from when it was originally planned to when it's finally, but that's going into. Maybe I could say, how is OLG prioritising high-risk councils in terms of, those ones that their revenue is more grant funding related than, say, their rate base? So there are councils that have greater relative need for financial assistance grants.
Yes, there are. Central Darling is an example of that. So Again, that's the risk-based approach that we're applying, the use of the quarterly budget review statement process.
And performance ratios.
And the review of the performance ratios.
Okay. I think that is... Yeah, because I was going to ask you about code of conduct, but I think... do you accept that councillors would still require access to frank and detailed briefings in order to make informed decisions?
The Minister provided testimony. He even complimented a letter that I signed that dealt with that. I'm not going to add any more.
No, okay. Okay, yeah. All right. I might put these as supplementary to the Minister then. That is my questions.
Concludes
Thank you.
the opposition's questions. Does the government have any questions?
The government does not have any questions at this time and would like to thank all the witnesses at the table for their comprehensive answers over the course of the day.
Thank you, Chair and Committee. Thank you for the courtesy shown to my staff as well. Thank you.
Thank you
all for being here.
Before we
work that you do.
conclude, I just want to give everyone the opportunity, if there was anything that they wanted to tidy up at the end, if there was something taken on notice that they've since had an answer for that they want to put on the record now.
I think we do need to publish on the grant finders.
Okay.
So that will be public.
Yeah. Fantastic. Thank you.
No, I'm pretty clear that the plug is being pulled as we speak.
Wonderful. Well, thank you very much to all of you for your attendance today and for your time and for all the answers. There was some questions taken on notice and there may be further questions from the committee, but the Secretariat will be in contact in regards to those. So thank you again.
Thank you.
Thank you very much.